certified copy. My lord, the order was passed on 2nd September by Lordship Sugoto Mojumdar, and we applied for 17th September. But my lord, leave your blessing.
You take for leave to file without certified copy, my lord. The order was passed, my lord, on 29th August, my lord. Let this, your lordship was already granted leave in.
When did you apply?
Application was,
Apply for certified copy.
yes, my lord. So immediately thereafter, my lord.
Dida.
Well, your lordship has already.
Let it be listed, sir.
Yes, ma'am. This is appellate side commercial.
Yes, sir. Commercial matter. Item number 2 application, item number 1 and 2.
Unless you don't want to put it. That's shared, baby. Only to one, just number 1.
Yes.
And for the 1.
Other side.
Huh?
Other side.
Yeah. There's certain pages missing, my lord, in there, my lord. Paper stay application, my lord. So we just made, my lord, this informal, my lord, supplementary paper. The last order, my lord, had directed us, my lord, to. Yeah, sure.
I'll see.
You know what it is?
Some pages are missing. We had recorded that.
Yes, my lord, we have just put that, my lord, in a supplementary, my lord, informal supplementary paper.
So the appeal has to be heard out.
Appeal has to be heard. It's, my lord, appeal, my lord, from an ad interim order.
That's, my lord, I want an interim order on the last, you may remember, on the last date, my lord, because the matter couldn't be taken up, and the matter was being taken up before the NCLT.
That is why, Mr. Bose, we protected you
Yes.
by saying that the NCLT will not
Yes.
or will defer
Yes.
the
That is one aspect of the matter. The second aspect of the matter is that this is an appeal from an ad interim order. The matter is fixed before learned single judge. My lord, after basically the finding of the learned single judge, effect of that order is basically, my lord, my NCLT proceedings get stayed, and more fundamentally, I have recalled the loan. So if I recall the loan, my lord, the entire amount becomes payable, and it is debt due. The ascertainment has to be done by the NCLT, which your lordship said until a fight. Now, my lord, they have filed another application because learned single judge has said in the impugned, if I show you the impugned order, has said, no, the recalling was bad. And therefore, my lord, a very paltry sum, because it is to be paid in a staggered manner. My lord, this, so, my lord, taking advantage of that order, they are paying when the entire sum has become now payable, and that becomes a debt due, which is to be ascertained by the NCLT. My lord, they are paying small sums of money and asking us to adjust it against, my lord, the installment on account of interest which is due and payable. So, my lord, as if I am, and the letter is as if I am in contempt, because I am adjusting as per the agreement, because the act
Its paltry sum of money is 12.5 crores.
maybe,
And my lord, all the
in
installments paid
installments.
with
That is-
interest
that is the
as
whole-
provided for in the
My
agreement.
lord, that is the
My lord, notwithstanding such payment, my learned friends, my lord, deem it fit to, my lord, recall the loan and to accelerate the payment of the entire
Yes.
money. And my lord, that is what was challenged. Now, my
Yes.
lord, this is an appeal against, my lord, only one thing.
My lord, the point,
My lord,
my lord, if this is the case, everyone m- my lord, if this is the case, everyone, my proceedings are prior, someone files a suit.
Please understand. We will have to decide
Yes,
whether the learned judge was right
Correct,
or
my
not
lord.
in holding that the recalling was bad,
Yes,
right? So we need to hear out the appeal.
yes.
So
my lord.
when will you address us in the appeal?
my lord,
I'm saying
one,
that's
one,
the-
my lord,
that's the
small
order
point
pass.
of demurrer.
Yes,
That is
My
the
lord, this is an appeal against an ad interim order.
yes.
Yes.
Directions were given to file affidavits. My learned friends have not filed affidavits. Had affidavit been
Yes.
filed, the matter would have been ripe and ready for hearing before the learned single judge. Now, my
uh,
lord, today the law is quite well settled that, my lord, your lordships will interfere with an ad interim order. Not only, my lord, lordships find that it could have been differently, my lord, passed, but when it is perverse and arbitrary. My lord, that is, my lord, the plethora of judgments of, my lord, the apex court, my lord, which decides the issue.
It is a jurisdictional
question is-
point. The effect of the interim order is to basically decree the.
My lord, if your lordship sees the
Lecture and-
order of the learned single judge, the learned judge has said that the NCLT will be free to decide the matter, my lord, as it wishes.
No, no. By holding that the recalling is bad. So when you go to the NCLT, it says what to do. Learned single judge has said recalling is bad, therefore money is not due.
Then, my lord, we have to wait for the adjudication of the entire suit.
That is the whole purpose. By filing a suit, my lord, the entire recall note.
Including your point of demurrer, when will you?
My lord, I'm for respondent one.
My lord,
Any day, except for next Friday, any day, my lord, puts it, my lord.
My lord, I am ready today. That's the order passed. You will may
For listing,
e-
for
e-
listing.
even its direction for paper book is not necessary, because I have prepared a index, which is and I am ready to address
No,
the short
no,
point,
understand.
which I'll
Mr.
address.
Bose, are your friends ready to address today? This is what we are trying to
Sir,
ascertain.
I am addressed because my predicament is the learned single judge matter is appearing next week, and then I have not filed any affidavit because it's a question of jurisdiction. What will I file? Because the learned single judge has already held that the recalling is bad.
That is fine. My lord,
And state
is,
the
is
notice.
third, my lord, convenient? Next Monday,
When is the matter returnable before the?
Well,
learned-
December, 11th December.
Oh,
Yes,
Yeah,
no,
December.
right?
Until December.
No, they have filed an application.
no.
17 November.
That's
The
17th
application-
November.
So third,
They
next
have-
Monday. Next Monday.
Well, I'm not standing in the way with next
No,
Monday.
next Monday.
I'm just let it retain its position because it's fixed on.
Appeal.
And Miller, they are threatening contempt.
Bishop, you could. What? Contempt, how?
It will be listed.
Miller, one thing, Miller, and they have sent a notice threatening contempt.
No,
because-
do not take any step.
That's
Well,
a letter.
No, no.
I'll tell you, lordship, my lord, only problem is this. I am offering payment. My learned friend is seeking to appropriate the payment against, my lord, what they perceive is the entire outstanding due.
Yes.
All right, Mr. Shah, since
That's
we
absolutely
propose to hear out the appeal next Monday, do not take any coercive
No,
step on that.
that's all. That's all.
Now, this will be listed as the, not as new application, since we'll hear out the appeal, as the first appeal from order.
Very well.
Great.
Issue. In terms of our order dated September 26, 2025, an index of papers has been filed.
হাল করেছে? আমাদের
দিয়েছে কৌশিক?
এটা কি?
এটা তো আমাদের পেপার পড়ছিল।
আরে ঝুট।
কোথায়?
দেয়নি?
Melod, from Chhath Puja they are carrying it still.
So you're not
কেটে
ready.
দাও index এ। কেটে দাও। You have filed a supplementary paper book.
Yes.
পেয়েছে। আচ্ছা, in terms of কেটে দাও ওটা। আচ্ছা হ্যাঁ, in terms of our order dated September 26, 2025, comma, the respondent number 1 has filed. Who has filed?
One.
Respondent number 1 has filed a supplementary paper book. Stop, let the same be kept with the records. Paragraph.
Melod, copy of my this index is there, but that won't be filing.
File it next Monday.
In course by
Fine.
No, let us have the
Officially
index.
served, my lord, on us.
Supply copy, file it next Monday. Paragraph, as we had recorded in our earlier order,
আমার কি? আমার সঙ্গে কে? তুমি? তুমি তো 7 এর।
as the purport of our earlier order was, comma, we wish to hear out the appeal. Stop. Let the appeal be listed. Why two appeals?
Give your name.
Why two appeals?
From an extension.
Melod,
তাহলে একসঙ্গে করবে।
there
Let
is no stay in that application.
Let the two appeals be listed as the first item under the heading appeal from orders on November 3.
Grateful.
Paragraph, the point of maintainability of the appeal is left open at the instance of Mr. Shaha and Mr. Banerjee, comma, learned senior advocates appearing for the respondent numbers 2 and 1 respectively.
Melod, the matter is fixed, will appear on 17 November, the application which they have filed. Melod, kindly, is it your lordship, in case it is not heard, you know, although it is number 1, you know, the new motions take precedence. So,
If such occasion arises, we'll see.
yes,
Anyway.
wait.
We'll see.
করবো না, এখানে যতক্ষণ না hearing. Grateful.
Question number 3.
Rachit Lakhmani.
Mr.
Rachit Lakhmani.
Yes.
My lord, he's before courtroom number 14 on legs. My lord, kindly give a short pass over. If not,
Pass
then
it
I'll
over. Both 3 and 4.
both 3 and 4.
Pass over. You wanna have it?
Orders. Item number 5.
This is my appeal.
Is there an interim order in this appeal?
Interim order is stay subject to that 8 crore bank guarantee. My application subsequently I have filed GA1 for return of the bank guarantee, factual apart from the fact that the shares have been sold.
Singh,
My lord.
the appropriate order according to us will be to send the matter to the tribunal with the subsisting interim order for a specified period of time, directing the tribunal to decide the issues involved within that time period without being influenced by anything we might have recorded in our orders.
That would be, my lord, practically allowing the appeal. My lord, my lord, there was no interim order at the section 9 stage before the single bench. I had succeeded before the single bench, my lord. In appeal, my lord, there's no order.
Moshmi Bhattacharya's order was there. Moshmi Bhattacharya's order was there.
Ultimately vacated when the section 9 was finally heard and disposed of. There was no interim order.
But in the appeal, isn't there an interim order?
In the appeal, my lord, there was an interim order, my lord, and Mr. Mitra has made his submission, my lord. We are in reply. My lord, we need only one more day to conclude. In the meantime, the section 11 my lord, has been allowed, which my lord, we are preferring my lord, an SLP my lord. My lord, the point here is today my lord, if disposes of the appeal my lord, with confirming the interim order my lord, for limited time my lord, that would be in practically allowing the appeal my lord.
No, not
Kindly my lord, hear us my lord, and then take the
interim
call.
order continues for a specified period. Now that you have a forum under section 17, why should we pry our mind any further? That is also what the courts generally do, Mr. Singh. You know that.
But I've got similar orders passed by the.
My lord, in that even, my lord, kindly, my lord, I am letting Mr. Chaudhary is not there today. My lord, kindly fix it on Friday, my lord. My lord, he is not there today, my lord. Kindly, my lord, let us come back on Friday, my lord.
I've got similar matters, civil orders.
I know, but Mr. Singh doesn't want to take it on his shoulders.
And Mr. Chaudhary, I'm sure will.
Accommodation is paid for on behalf of the respondents. You appeal for all the respondents.
Yes, my lord.
Paragraph lists this matter once again. Friday date diye dao. Under the same heading, comma, retaining its position.
Item number 6.
But I'm praying for a short passover. Mr. Mitro is on his
Look,
legs.
So, my lord, the EPL matter, my lord, where I have, my lord,
This is very unfortunate, sir. We have kept it at as number 1, specially fixed. He's on Mr. Banerjee concluded on the last day. We'll wait for him, inform him. He's on his way. If he's on his way, we'll wait for him. Matter of Passover আছে নাকি? Call.
Passover matter, new application, item number 3.
Your Lordship, Passover was sought on behalf of Mr. Rachit Lakhwani by the petitioner.
Mr. Banerjee, we'll take this up
Yes, my lord.
as soon as Mr. Mitro is here.
I'm here.
Yes, Passover appellant is not here, sir. Madam. Not today. Not today. আমার ফার্স্ট কল করে যাওয়ার কি হবে বসে না থেকে
Item number 7. 7 এর নামটা কি?
7 minute I appear for the appellant.
No, Mr. Kaur, we are just running through the list because we are waiting for Mr. Joyanto Mitro.
The problem is that we are in deficit blood in filing the paper book.
Oh, that we'll allow.
Kindly.
Yes. You are the appellant.
I'm the appellant.
I appear for the respondent award holder, my lord.
Huh?
I appear for the respondent.
Yes, fine. You file it in the department, please.
Then Lord, kindly.
We'll grant leave.
Okay.
Leave is granted.
Yeah.
Leave is granted to the appellant to file. Leave is granted to the appellant to file paper books in the department by the end of court hours.
Today?
Tomorrow. Day after tomorrow. Date the other. You need the server copy. Therefore.
But I believe, Lord, in terms of your Lordship's earlier order, the date of filing the paper book is today. So
But then you have time.
We have time. But only thing is that since the matter is appearing in the list, I thought, Lord, we'll take leave.
Very well. তাহলে লিখুন এটা কেটে দাও কেটে দিয়ে লেখো
You have the order.
The appellant says that paper book is ready and will be filed in the department in course of the day. Stop. Let that be done. Paragraph. List this matter once again. Friday date thou. Retaining its position. Friday is all right with you?
Yes, Lord, it's all right. I'm just checking up that
Date.
Under the no, where is the time to file the paper book? Or the,
Finding the first one.
No. Lord, I'm really sorry, Lord. We need extension.
You'll
Because
need
the order, Lord, does not say the paper book to be filed by 27th. The order directs, Lord, the appeal to appear on the 27th.
time to file
I'm
paper
really
book.
sorry.
Time to file paper book is extended till Friday date the
Till
Friday.
Wednesday, Lord, let it
अच्छा
appear.
Wednesday date the Wednesday date
appear
the
on.
हाँ ठीक है जी paragraph list the matter on Friday date the retaining its position.
I'm really sorry, Lord.
No. You all right now? Absolutely all right?
Absolutely.
Oh. Mr. Bose, we'll have to take up Mr. Mitro's matter.
Yes.
Hmm.
But
So
if I don't have
pass
to,
over.
Lordship will dismiss.
Pass over.
But only thing is,
My Lord,
Pass over, you want it some other day.
kindly keep it on Monday, my lord. I'm in some difficulty after recess.
ठीक है. There comes Mr. Mitro. So
Sir, বলছেন তো?
not this week.
Yes, Monday ঠিক আছে. Because I have a শুনবে, Mr. Shomo Rai Chudhuri is my junior.
Yes, of course.
In any event, he said he is not available next Friday. So at his request, you are doing it. My Lord.
Not this week.
My Lord, yes, only fixer. My Lord, if your Lordship can.
Retaining it will retain its position, Mr. Bose. We can't fix a time for every matter. Call the gas matter.
Gas matter. Come on, Lord. Oh, fix. Gas matter.
Cutting about, I have exhausted my gas.
Take your time. Sit down. Can we offer you some water?
This reminds me of Tagore, my lord. শ্রান্ত চরণে চলি পারে যাত্রা হয়েছে মোর সাঙ্গ সুর থেমে আসে বারে বারে ক্লান্তিতে আমি অবসাঙ্গ. My lord, my state is that.
Most inappropriate. Absolutely doesn't apply in this case. Ore nobin, ore amar kacha.
রবীন্দ্রনাথ বলে যাচ্ছে এবং রিপ্লাই দেবেন
Yes, Mr. Mitro, you'll consume the first half?
First half, I think I should.
First half, released.
Accept this matter.
Mr. Mitro, your Mitro institution.
My lord?
Mitro institution, no.
No,
Paliganj government. They used to teach Rabindranath there also.
Yes, of course. We had the
But we are Patho Bhavan.
Well, I think more or less.
গরম হচ্ছে কেন ভাই? দূর হচ্ছে না, আশ্চর্য ব্যাপার।
But nowadays we don't hear this. আপনি সারা মুখ করছো কি? তুমি জানবেন সাইড করেছো 35টা। তুমি করে এসো অন্যবার, কোনো অসুবিধা নেই।
I go straight to the decisions which have been cited because I am in reply. My lord, which judgment, my lord, had impressed me, and I am sure, my lord, it must have impressed your lordship, is the judgment of the uh, English High Court, Justice Upjohn's judgment, my lord, in 1955 1. That is one judgment when, my lord, it was placed by my learned friend. I tell your lordship very frankly, I had my reservations. I somehow I felt that it was inconsistent with Section 73. of the Contract Act. And so, my lord, I had to, when I read the judgment, I thought that there are distinguishing features which perhaps I should bring it to your lordship's notice. My lord, kindly take, my lord, 1955 two weekly law reports, page 185, which has been cited by them. I go straight to the decisions. এটা বোধহয় পাবেন আপনি, হ্যাঁ, এটা ইয়েতে রয়েছে, কম্পাইলেশনই রয়েছে।
First volume.
My lord, it is in their page 57. Page 57. My lord, kindly take page 58, where the facts have been set out.
Sir Mitru, page 57 of?
Page 57 of the volume of judgments which have been cited by them. And in fact, my lord, it is also there. Perhaps it will be easier for your lordship to take the respondents' judgments in the, my lord, in the second set which has been handed up.
Yes.
That is, my lord, as a thinner volume, perhaps it will be easier for your lordship to handle. In fact, my lord, I found that the decisions which they have cited, my lord, with the stitching on the corner,
yes,
were very inconvenient. So what I did was I got mine one
spirally bound.
It is easier to open and easier to handle. Please take note.
Since Malad, I apologize, Malad, since we did not get any copies of the judgments from Malad the side, Malad.
Now, this is the judgment cited by you.
So I apologize. Yes.
Why are you on the virtual mode? Chhat Pujo.
No, Malad. I apologize, Malad. I'll.
Oh, I see.
Yes.
My lord, kindly take, my lord, page 57. It is, my lord. I think it will be in your lordship's copy also, page 57.
Yes.
Thompson versus Robinson Gunmakers, 1955-1. Well, kindly see the facts first, which your lordship will be pleased to find at page 58. The plaintiffs, W.L. Thompson, were the agents and dealers in new and second-hand cars who carried on business in Hull. The defendant company, R. Robinson Gunmakers Limited, were manufacturers and suppliers of guns with no interest in the motor trade. The managing director of the defendant company required a motor car for the business of the company, and it was common ground that on March 4, 1954, the managing director on behalf of the defendant company signed an order for the purchase of a Vanguard, well, it is standard Vanguard car. Your lordship remembers the round shaped. Perhaps I don't know whether your lordship remembers. It's quite sometimes back, my lord. We
seen photos, haven't seen the car.
Oh, you are not. This was, my lord, when this particular car was imported in India. This created some amount of stir because of the shape. The first time we saw a completely round shaped car.
At the rear.
At the rear, it just came and sort of.
So was Landmaster.
That was afterwards.
Afterwards.
Yes, but Landmaster is, well, the roof and then, well, protrusion at the back. But, well, this one is completely round.
Oh, I see. I see.
Hindustan 14 ওরকম ছিল না, round Vanguard তোমরা দেখোইনি. The standard Vanguard, my lord, that became a fashion of the day at that time because of its shape.
My father had bought a second-hand Hindustan 14,
yes,
and he used to tell me later in life that it used to run 40 kilometers on 1 liter. When I didn't believe him, he said, well, on petrol 10 kilometers and rest by pushing. It used to get stuck ever so often.
I was also with seriousness listening to this.
Yes.
But that was a very good car. Hindustan 14 is a very reliable and durable car. Ambassador. WPF. For the purchase of a Vanguard motor car from the plaintiffs, an old car being taken in part exchange. On 5th March 1954, the defendants refused to accept delivery of the Vanguard car, and the plaintiffs claimed damages for their loss of profit, amounting to 61 pounds. The defendant contended that the damages were only nominal. The point of principle involved was of the importance of the motor car trade, and the action was supported by the British Motor Trade Association. Kindly note this. The point of principle involved was of importance to the motor car trade, and the action was supported by the British Motor Trade Association. And as it appears, the defendant's case on the facts might be in jeopardy. The following arrangement in conduct of the action was approved by Justice Upjohn. The defendant company, for the purpose of this action, admitted that there was a binding written agreement for the purchase of the motor car in question. It was conceded that it was broken the day after it was signed, when the defendant company intimated that it was not prepared to accept delivery of the Vanguard motor car. It is also admitted for the purpose of the action that at the East Riding, Yorkshire, the transaction actually took place in Hull. At the time of the contract of sale, there was no shortage. Can I note these words? There was no shortage of Vanguard models to meet the immediate demands in the locality. In return for those concessions, the plaintiff were prepared to indemnify the defendant against the cost of the action. So, my lord, it was as a fact considered that there was no shortage of Vanguard models, because this is going to assume some importance in the facts of this case. Next paragraph. It was proved first that in common with other makes of motor car, dealers were only permitted to sell new Vanguard cars at a price fixed from time to time by the manufacturers, the Standard Motor Car Company. If the dealer broke that rule, he was put out of business. The dealer's profit on the transaction was also fixed. He would have received, in the case of a commission of 10% on the list price of the Vanguard and accessories such as wireless heaters supplied therewith. In this case, the amount of profit he would have made was 61 pounds, 1 shilling and 9 pence. When the defendant company repudiated the transaction on March 5, 1954, the plaintiff mitigated their damage by rescinding the contract with their suppliers. The supplier was a company called George Thompson Limited, the main distributor for the East Riding, a company closely associated with the plaintiff. They took back the Vanguard car, which they had already supplied to the plaintiffs, free of any claim for damages, and later sold the car on 5th May 1954 to another purchaser. So, my lord, the dealer did this after it was sent back to them. It was also common ground at this stage. The plaintiff lost a sale in the sense that if another purchaser had come into the plaintiff's premises, there was available for another purchase a Vanguard car for immediate delivery, so that the effect on the plaintiffs was that they had lost their profit on a sale, having sold one Vanguard less than they would have otherwise done. The plaintiffs contended that the true measure of damage in the circumstances was no more and no less than their loss of profit, namely 61 pounds. The defendant said that the loss was nominal, for the plaintiff could have sold the car to another customer, or could do what in fact they did, get their supplies to release them, and they had thus suffered no damage. Now, the judgment of Mrs. Upjohn. This action raises a question of some importance to the motor trade. Now, kindly note, well, I found that this particular judgment was confined to the peculiarities of the motor trade, which was at that particular point of time. And I shall make good my submission, my lord, as I go on. This action raises a question of some importance to the motor trade as to the true measure of damage where the buyer of a motor car, in this case Standard Vanguard, refuses to complete bargain and take delivery. The facts have been stated there. The law is not really in doubt. It is set out in section 50 of the Sale of Goods Act. Well, at section 50, subsection 1 and 2, I shall show to your lordship, it is, my lord, similar to section 73. And, my lord, subsection 3 of section 50 of the English Act, that is concerned with, my lord, the market, available market, the concept of available market. I shall come to it. The laws in Sale of Goods Act. That section was declared of the existing law, and the general principles which had been observed in all cases I take conveniently from the speech of Lord Holden in British Westinghouse versus Underground Electric Railways, where he said this, then quote, subject to these observations, I think that there are certain broad principles which are quite well settled. The first is that, as far as possible, he who has proved a breach of the bargain to supply what he contracted to get is to be placed, as far as money can do it, in as good a situation as if the contract had been performed. This is section 73. That is the general rule. Apart altogether from the authority and statute, it would seem to me on the facts, note the words, on the facts, which I have to consider to be quite plain, that the plaintiff's loss in this case is the loss of their bargain. They have sold one Vanguard less than they otherwise would. The plaintiffs, as the defendant must have known, are in the business as dealers in motor cars and make their profit in buying and selling motor cars. And what they have lost in their profit on the sale of this Vanguard, there is no authority exactly to the point. In this country, although it seems to me that the principle to be applied is a clear one, it is to be found in Wickmill Limited. In that case, the supplier was to supply certain machines which he had to make, and they were to be made to the particular specification of the purchaser, although they were of a type generally in common use. It was not the present case of a sale by a motor dealer of a standardized product. The purchaser repudiated his order, and with a view to mitigating the damages, the supplier, on getting another order for somewhat similar machinery, very sensibly made such alterations as were necessary to the machinery that he had made for the original purchaser, and sold the machinery so altered to the second purchaser. His costs of doing that were comparatively trivial. It was said by the supplier that the measure of the damages was the loss of the bargain. By the purchaser, that the measure of the damage was merely the cost of conversion of the machinery for the second purchaser, and his slight loss on the resale. Lord Justice Hamilton, after setting out the facts, said this. Then quote, that was a reasonable mode of mitigating the damages, but it by no means follows that the damages are confined to the cost, a trivial one, of adapting the machine to the needs of the second customer, and the loss on resale to him, which was only 23 pounds, making 28 pounds in all. The fallacy of this is in supposing that the second customer was a substituted customer that had all gone well. The makers would not have had both customers, both orders, and both profits. In fact, what they did, acting reasonably, and I think very likely, more than reasonably in the interest of Wickmill, was to content themselves with earning the profit on the second contract at the cost of adapting the machinery, which has been taken at £5. But they are still losers of the profit which they would have made on the Vic Mills contract, because they could, if they had been minded, have performed both the contracts and have the profit on both the contracts, but for the breach by the Vic Mill company of their contract. My lord, kindly note, this observation has been made in this judgment of Vic Mills, and the observation which has followed is in respect of a particular car, particular machine. This is in respect of a particular machine which has been made to alter and has been sold. In the instant case, it's a Vanguard car which was meant to sell. So the point is this, that individual car, machine, etc., the law which is being applied on the facts of that particular case. And my lord, it was my lord, the court proceeded on the basis that this particular thing would be available elsewhere also. In this particular case, the market was not available. And that is what, my lord, tilted the balance, which, my lord, will appear from the judgment itself. Kindly, my lord, come to Lord Justice Buckley's judgment in the next paragraph. As regards number 1, where the goods were manufactured, the respondents are, I think, entitled to both profits, because they were not bound to give the appellants the benefit of another order that the respondent had received. The respondents were left with these goods on their hands. They altered them and sold them to another buyer, but they could have made and would otherwise, I suppose, have made other goods for that buyer and not employed these goods for that purpose. If they had done so, they would have made both profits. So, my lord, it is considering, my lord, an object which is, my lord, in present time, present before the seller and the purchaser. The purchaser did not take it, committed breach of the contract. The seller sold it in the market. The market which was available, there, my lord, there was a shortage of Vanguard cars. This, my lord, had weighed very much with the, I shall show to your lordship from this judgment. It seems to me, next paragraph, that in principle that covers this case. True, the motor car in question was not sold to another purchaser, but the plaintiff did what was reasonable. They got out of their bargain with George Thompson, but they sold one less Vanguard and lost their profit on their transaction. In re Vic Mill Limited has been followed and applied to exactly the circumstances I have before me. That is to say, the sale of motor car. In a number of cases abroad, to which I have been referred, in Cameron versus Campbell, etc., a judgment of the Supreme Court of the States of South Australia, the head note reads, where the purchaser of a motor truck, again, my lord, see, my lord, motor truck, chassis, from a dealer, refuses to accept delivery of the motor truck, which was then resold at a profit, there being evidence that similar motor trucks were available for immediate delivery, and the property not having passed, held that the seller was entitled to retain the profit on resale and also to damages for loss of profit on the original sale. In Vic Mill followed, and my lord, the Vic Mill has been quoted here. Then, my lord, kindly come to the paragraph, the penultimate paragraph on that page. The main case, however, put by the defendants in this is this. They submit that subsection 3 of section 50 applies, because they say there is no available market for the goods in question.
Sir, there is an available.
They say that there is an available market for the goods in question. And in that available market, we know that the price of the Vanguard is fixed. It is fixed by the manufacturers. Therefore, they say the measure of damages must be necessarily be little more than nominal. Had the plaintiff kept the car sold to another at a later stage, no doubt they would have been entitled to the cost of storage in the meantime, possibly interest on their money laid out, and so on. But as they had in fact mitigated their damages by getting out of the contract, the damages are nil. Mr. Plaxmill said that the market now must not be treated as a market in fair in a limited technical sense. Well, I am not troubling your lordship. Kindly come to the Dunkirk Colliery judgment. Well, kindly note that section 50, subsection 3 has been relied upon. Let me place this paragraph. Mr. Plaxmill said that the market now must not be treated as a market or fair in a limited or technical sense. It is curious that there is comparative absence of authority on the meaning of the phrase available market, because one would have thought that there would have been many cases, but the researches of counsel have only disclosed one authority on section 50, subsection 3. It is the case of Dunkirk Colliery versus Liver, a decision of the Court of Appeal. The facts were far removed from the facts before me, and I need not recite them. It will be sufficient if I read an extract from the judgment of Lord Justice James, and then my Lord judgment. Under those circumstances, the only thing that we can do is to send it back to the referee with an intimation that we are of opinion upon the facts, agreeing with the master of the rolls in that respect, that the facts do not warrant the application of the principle mentioned in the award, namely that there was what may be properly called a market. What I understand by a market in such a case as this is that when the defendant refuses to take the 300 tons the first week or the first month, the plaintiff might have sent its wagons somewhere else where they could sell it, just as they sell corn on the exchange or cotton at Liverpool. That is to say that there was a fair market where they could have found a purchaser either by themselves or through some agent at some particular place. That is my notion of meaning of the market under those circumstances. If that be the right principle to apply, it was proved that there is nothing in the nature of a market like cotton exchange or Baltic or stock exchange or anything of the sort for the sale of new motor cars. My Lord, kindly mark these words. I am reading it again. If that be the case, right principle to apply, it was proved, and this is what was proved, that there was nothing in the nature of a market like a cotton exchange or Baltic or stock exchange or anything of the sort for the sale of new motor cars. My Lord, this is one of the points which, my Lord, the plaintiff is required to prove. A person who is claiming damage cannot just, my Lord, throw the principle of claiming damage just like that without substantial backing by way of evidence. In our instant case, this evidence is absent. And if this evidence is absent, well, I respectfully submit to your lordship, the question becomes whether the claimant is entitled to claim damages. My lord, this is the most important sentence in this, and I shall show to your lordship why it is important. It was proved that there is nothing in the nature of a market like cotton exchange or Baltic or stock exchange or anything of the sort for the sale of new motor cars. Then, but Mr. Plaxmill's submissions have been made. I am not troubling your lordship. Kindly come to the next paragraph. It is curious that in section 51, subsection 3 of the Sale of Goods Act, a subsection in identical terms with section 50, subsection 3, which relates to the remedies of the buyer when the seller defaults, it is, my lord, the other side of the coin. A somewhat different view of the word market has been taken from that expressed by Lord Justice James. The only case to which I have been referred is Marshall and Company versus Nicole. Then, my lord, I am not troubling your lordship with all this. Then, my lord, kindly come to the last paragraph on that page. Had the matter been res integra, your lordship has got that? Had the matter been res integra, I think that I should have found that an available market merely means that the situation in the particular trade in particular area was such that the particular goods could freely be sold and that there is a demand sufficient to absorb readily all goods that were thrust on it, so that if a purchaser defaulted, the goods in question could readily be disposed of. Indeed, Such was the situation in the motor trade until very recently. Kindly note this. Indeed, such was the situation in the motor trade until very recently. It was, of course, notorious that the dealers all over the country had long waiting lists for new motor cars. People put their names down and had to wait 5 or 6 years. And whenever a car was spared by the manufacturer from export, it was snatched at, and if the purchaser fell out, there were many waiting to take his place. And it was considered that if those circumstances were still applicable to Vanguard motor car, the claim for damages must necessarily have been purely nominal. Kindly note this. This is one of the distinguishing features. Whether there was an available market for sale of this. If available market was there, then I am sure one of the judgment would have been the other way. Then, my lord, it would have been held that this particular car had been sold to somebody else. I was just wondering this. If I want to sell my
Lord, I apologize, my lord. I'm unable to hear anything, my lord. I apologize, my lord. But the microphones have been muted, it seems, my lord.
So may I hear Mr. Kejriwal? Maybe perhaps he cannot. He's taking the notes, so he thought.
My lord, even the YouTube has got muted. That's why. And now I can hear. Great.
Well, I can assure Mr. Kejriwal that I am not responsible for it. You can copy the other second copy. This is reported in the weekly law report as also All England report. My dear Lordship can make a note of it. This is Charter versus Sullivan. The decision has been by the Court of Appeal, consisting of Lord Justice Jenkins, Hodgson, and Sellers. And this was also considering case of a motor car and section 50. Well, in that case, it was standard Vanguard. In this case, Hillman Minks. Your Lordship had not seen Hillman Minks, I suppose. Hillman Minks, তোমরা দেখেছো কখনো?
What?
Hillman Minks. Lordship's education is not complete.
In fact, the first time I saw a Datsun car was in Igdalia.
Datsun. Yes. That's right. I think obtained 1991 or something like that. 1991.
আমার একটা Datsun গাড়ি আছে।
জানি তাই ওটাই তো বলছেন যাচ্ছে।
ওইটাই?
হ্যাঁ।
It is what?
হচ্ছেন তো তাই বলছেন একডালি আর কাকে দেখবেন।
That was
Silver color.
yes. That was I think older than me in age. I don't know why my father was enamored by this car. It was so difficult to get into the car and get out of it.
And you didn't require a horn.
Yes, I don't know. Sufficient noise was there from the car itself. Copy দিয়েছি?
হ্যাঁ, copy দিয়েছি। Thank you.
Well, here also kindly see section 50 subsection 1 of the Sale of Goods Act, which is section 73. Like, well, kindly come to straight to the judgment. Well, this is also reported. Your Lordship can make a note of it in 1957. One All England reports 809. The facts, my lord, kindly note, kindly come to this. Well, here, one good thing is this, my lord, section 50 of the Sale of Goods had been quoted here. In the head note itself, your Lordship will please to find it is quoted not in full, but my lord, to the extent it was necessary. By section 50, subsection 1, these are the sections which will be important in this case. Of the sale of goods, where the buyer wrongfully refuses to accept and pay for the goods, the seller may maintain an action against him for damages for non-acceptance. Then subsection 2, the measure of damage is the estimated loss directly and naturally resulting in the ordinary course of events.
Sorry, where are you reading?
Well, I'm reading the head note.
Head note, I see.
Head note, kindly, because section 50 will be required.
Yes.
Section 51, subsection 1 is, where the buyer wrongfully refuses to accept and pay for the goods, the seller may maintain an action against him for the damages for non-acceptance. Then subsection 2, the measure of damage, this is section 73 in our my lord Contract Act. The measure of damage is the estimated loss directly and naturally resulting in the ordinary course of events from the buyer's breach of contract. 3, where there is an available market for the goods in question, the measure of damages is prima facie to be ascertained by the difference between the contract price and the market or current price. The defendant refused to accept delivery of a Hillman Minks motor car, which he contracted to buy from the plaintiff, a motor dealer at the retail price fixed by the manufacturer. Within 10 days, the plaintiff resold the car to another purchaser. In an action by the plaintiff for breach of contract, the county judge County Court judge awarded the plaintiff $97.15, the loss of profit on the repudiated sale. The defendant appealed on the ground that the true measure of damages was the difference between the market value and the contract price, and that the plaintiff had not suffered any damages, since he had subsequently resold the car for the agreed price. It was held that whether there was an available market within the meaning of Section 50, subsection 3 or not, the present case was one in which the general rule laid down in subsection 2 should be applied, to the exclusion of subsection 3. Accordingly, as the evidence showed that the plaintiff could sell all the Hillman Ming's cars that he could get, he had not shown that he had suffered any loss directly or naturally resulting from the defendant's breach, and he was entitled only to nominal damages. My lord, kindly see, Thompson versus Robinson has been cited, and it was distinguished. Why it, and how it was distinguished, my lord, I shall show to your lordship. My lord, let us come to the judgment straight away. My lord, your lordship will be pleased to come to the third page of that. Lord Justice Jenkins' judgment. Lord Jenkins stated the facts set out above and continued. I now turn to consider what, on the undisputed facts of the case, is in the eye of the law the true measure of the damages, if any, over and above merely nominal damages which the plaintiff has suffered through the defendant's failure to take and pay for the car he agreed to buy. Consideration of this question must inevitably begin with reference to Section 50 of the Sale of Goods Act. His lordship read Section 50 and continued. Mr. Collard for the defendant argued that in the present case there was an available market for Hillman Ming's deluxe saloon cars within the meaning of Section 50, subsection 3 of the Act, and accordingly that the measure of damage ought, in accordance with the prima facie rule laid down by the subsection, to be ascertained by the difference between the contract price and the market or the current price of at the time the defendant refused to perform his contract. The result of this argument, if accepted, would be that the plaintiff could claim no more than nominal damages because the market or the current price could only be the fixed retail price, which was necessarily likewise the price at which he sold to the defendant and resold it to Wigley. But the plaintiff is a motor car dealer whose trade for the present purpose can be described as consisting in the purchase of recurrent supplies of cars of the relevant description from the manufacturers and selling the cars so obtained or so many of them as he can at a fixed retail price. He thus receives on each sale, he is able to effect the predetermined profit allowed by the fixed retail price, and it is obviously I was, my lord, in the second paragraph at page 531, top. He thus receives on each sale, he is able to effect the predetermined profit allowed by the fixed retail price, and it is obviously in his interest to sell as many cars as he can obtain from the manufacturers. The number of sales he can effect and consequently the amount of profit he makes will be governed according to the state of trade. According to the state of trade, either by the number of cars he is able to obtain from the manufacturer or by number of purchasers he is able to find. In the former case, the demand exceeds. In the former case, demand exceeds the supply, so that the default of one purchaser involves him in no loss, for he sells the same number of cars as he would have sold if the purchaser had not defaulted. In the latter case, the supply exceeds demand, so that the default of the one purchaser may be said to have lost them on sale. Well, this is the very important sentence. In the former case, demand exceeds supply, so that the default of one purchaser involves in him no loss, because the demand exceeds supply, he can find another purchaser to sell it. For he sells the same number of cars as he would have sold if the purchaser had not defaulted. In the latter case, where the supply is more than the demand, the supply exceeds demand, so that the default of one purchaser may be said to have lost him one sale. Then, my lord, kindly come to. So, my lord, it becomes a matter of evidence. Then, my lord, kindly come to the next page. Kindly come. Yes. I come to, my lord, straight away to the second paragraph dealing with Thompson and Robinson. Your lordship has got that? In Thompson and Robinson, Justice Upjohn had before him a claim for damages in a case resembling the present case to the extent that damages were claimed in respect to the defendant's refusal to perform a contract with the plaintiff for the purchase from the plaintiffs of a car, in the instance case a standard Vanguard car, which, like the car in the present case, could only be sold by the plaintiff at a fixed retail price. It is, however, important to note that the case to which I am now referring proceeds on certain admissions, including an admission to the effect that in the relevant district at the date of the contract, which was also the date of the breach, there was no shortage of Vanguard models to meet the immediate demand of the locality, which I placed before your lordship. This very sentence I placed before your lordship, which I take to mean, in effect, that the supply of such cars exceeded the demand. In these circumstances, the plaintiff, by agreement with their suppliers, rescinded their contract with them and returned the car. In the ensuing action, the plaintiffs claimed from the defendants the damages amounting to the profit the plaintiffs would have made on the sale of the car to the defendants if the defendant had duly completed their purchase of it, and the judge held them entitled to those damages. The defendant raised the same argument as has been raised with the defendant in the present case, namely that there was an available market for a car of the kind in question, within the meaning of section 50 subsection 3, that there was a market or current price in the shape of fixed retail price, and that as fixed retail price was the same as the contract price, the plaintiff had suffered no damage. In the course of his judgment, Justice Upjohn referred to Lord Justice James's definition of a market in Dunkirk Colliery. Then, my lord, it has been quoted. Then, my lord, kindly come to the next paragraph. Justice Upjohn went on to propound a more extended meaning of the phrase available market in these terms. Then, quote, had the matter been res integra, I think I should have found that an available market merely means that the situation in the particular trade, in the particular area, was such that the particular goods could freely be sold, and there was a demand sufficient to absorb readily all the goods that were thrust on it, so that if the purchaser defaulted, the goods in question could readily be disposed of. He went on to say, in effect, that in the case then before him, there was no available market because the supply of Vanguard cars at the material time exceeded the demand. I doubt if Lord Justice James's observation in Dunkirk Colliery should be literally applied as an exhaustive definition of the available market. On the other hand, I do not find Justice Upjohn's definition is entirely satisfactory. So, Mother, there is some amount of doubt which has been led by the Court of Appeal with regard to the finding of the Mr. Upjohn. And he is saying so. After, my lord, saying all this, making a distinction between the case before him and before Mr. Upjohn, the court, my lord, said, on the other hand, I do not find Mr. Upjohn's definition entirely satisfactory. I will not, however, attempt to improve upon it, but will content myself with a negative proposition that I doubt if there can be an available market for particular goods in any sense relevant to section 50 subsection 3 of the Sale of Goods Act, unless those goods are available for sale in the market, at the market, or current price, in the sense of the price, whatever may be fixed by the reference to supply and demand as the price at which the purchaser for the goods in question can be found, be it greater or lesser or equal to the contract price. The language of section 50 subsection 3 seems to me to postulate that in cases to which it applies, there will or may be a difference between the contract price and the market price, which cannot be so when the goods can only be sold at a fixed retail price. So section 50 subsection 3 was not taken note of. The court said that section 50 subsection 3 will not apply in a case like that. So applied, my lord, section 50 subsection 1 and section 50 subsection 2. Section 73 was applied in this case. Accordingly, I am of the opinion that whether there was in this case an available market within the meaning of section 50 subsection 3 or not, it is a case in which section 50 subsection 2 should be applied to the exclusion of section 50 subsection 3. Then, my lord, the court says, next paragraph, it remains therefore to ascertain the loss, if any, naturally resulting in the ordinary course of events from the defendant's breach of contract, and the measure of that loss must, in my opinion, be the amount, if any, of the profit the plaintiff has lost by reason of the defendant's failure to take and pay for the car he agreed to buy. Section 73, properly applied. I should next refer to the evidence to which I have deferred consideration earlier in this judgment. So, my lord, evidence has to be taken. Evidence becomes important, my lord, in a case like this. Now, your lordship will please to come to when the submissions of the learned counsel for both sides had been considered. And in the next page, page 535, first, second, third paragraph, he says, the Lord Justice Jenkins said that I have not overlooked the evidence given by the plaintiff's storeman Harold Charles Charter and noted by the judge as delivery Hillman beings not easy at this time, might have to wait for some time. But I attach no importance to it because, as will hereinafter appear, the judge preferred the evidence of Winter. So, my lord, somebody else's Winter. There was there was contrary evidence. My lord, there was Harold Charles Charter had given one kind of evidence. Winter had given another kind of evidence. The court had the opportunity of choosing one as against the other. Then, my lord, kindly, next paragraph is also important. The matter therefore stands thus. If the defendant had duly performed his bargain, the plaintiff would have made on that transaction a profit of £97.15. The calculation accordingly starts with a loss of profit through the defendant's default of £97.15. That loss was not cancelled or reduced by sale of the same car to Wigley. For if the defendant had duly taken and paid for the car he agreed to buy, the plaintiff could have sold another car to Wigley, in which case there would have been two sales and two profits. See in re of the Wig, etc. Lord Justice Hamilton and Lord Justice Buckley's judgment. The plaintiff must further show that the sum representing the profit he would have made if the defendant had performed his contract had in fact been lost. Here I think he fails. This is very important, my lord. See how the evidence is being looked into. The plaintiff must further show that the sum representing the profit he would have made if the defendant had performed his contract has in fact been lost. Here I think he fails. In view of Winter's evidence to the effect that the plaintiff could sell all the Hillman Ming's cars he could get.
Again, এখানে excess আছে.
Next paragraph, my lord, again reiterates this. I have already expressed my opinion as to the meaning of this statement. It comes, I think, to this. that according to the plaintiff's own sales manager, the state of trade was such that the plaintiff could always find a purchaser for every Hillman Mings car he could get from the manufacturer. And if that is right, it inevitably follows that he sold the same number of cars and made the same number of fixed profits as he would have sold and made if the defendant had duly carried out his part.
We will keep if that data. We'll come back, Mr.
Lordship.
Short break.
বিগ মিলসের কেসটা হচ্ছে মেশিন বিগ মিল যেটা ওর রেফার করে হয়ে গেল ব্রিজ whether he has suffered damage or not. Take that. That's My lord, kindly come back, my lord, to this judgment again, 1957 2 All England Report. Page 535, I was reading before, Lordship. And the paragraph, I think the last but one, the penultimate paragraph on that page.
Page, sorry, page.
Page 535.
Yes.
There, my lord, after my lord, referring to Vic Mill's case, the appeal court judgment of Lord Justice Hamilton and Lord Justice Buckley. Here, this court says, the plaintiff must further show that the sum representing the profit he would have made if the defendant had performed his contract has in fact been lost. Here, I think he fails, in view of Winter's evidence to the effect that the plaintiff could sell all the Hillman Ming's cars he could get. This was the evidence on record. In our case, my lord, specific question was asked of the witness, of the claimant. What is this you are talking about? This flaring of gas. He said that I don't know. And my lord, reliance had been placed by the court on the contrary upon, my lord, the so-called finding in the CCI case confirmed by, my lord, Delhi High Court, which is not a finding at all, which is a submission, and that had become the foundation for the awarding of damage. This is what I am questioning. The scope of my argument is very limited. I am not, my lord, I have not argued in the way it was argued in the trial court, widening the scope. I have, my lord, confined myself to a very limited question issue. Damage has been suffered, you say. Have you proved it? And here also the same thing. Here I think he fails in view of Winter's evidence to the effect that the plaintiff could sell all the Hillman Ming's cars he could get. The next paragraph, I have already expressed my opinion as to the meaning of this statement. It comes, I think, to this, that according to the plaintiff's own sales manager, the state of trade was such that the plaintiff could always find a purchaser for every Hillman Ming's car he could get from the manufacturer. And if that is right, it is inevitably follows that he sold the same number of cars and made the same number of fixed profits as he would have sold and made if the defendant had duly carried out his bargain. Justice Upjohn's decision in favor of the plaintiff dealers in Thompson and Thompson was essentially based on the admitted fact that the supply of cars in question exceeded the demand. This was the basis. So, my lord, I am saying, my lord, your reliance upon Justice Upjohn's judgment is not justified by reason of the absence of evidence which you have failed to lead before the arbitral tribunal. My lord, then again, kindly come to page. I'm not troubling your lordship, my lord. The evidence has been extensively dealt with in this paragraph. And his judgment leaves no room for doubt that if the demand had exceeded the supply, his decision would have been the other way. And then, my lord, the evidence has been dealt with. Kindly, my lord, come to the next page, page 537. First, second, third paragraph. After, my lord, considering all this, my lord, kindly come to the second paragraph. The materials before the court leave a good deal to be desired. The parties were no doubt preoccupied with the issue of contract or no contract, contract or no contract. And the argument in regard to damages based on Thompson's case was perhaps something of an afterthought, as is suggested by the belated and, as I think, unnecessary amendment to the points of claim, substituting a second motor car for the said motor car in the first claim of damage. So, my lord, the court says the parties no doubt occupied the contract to no contract, as was in our case in the trial court. And secondly, the argument regarding Thompson. But then next paragraph is important. But it was for the plaintiff to prove that he did in fact sustain the loss of profit claimed. And this, to my mind, he wholly failed to do. The mere assertion by Winter, we have lost sale of a car, is clearly not enough, particularly when read in conjunction with quote, can sell all the Hillman Mings we can get. Accordingly, there was, in my view, no evidence on which the judge could properly hold that the plaintiff had suffered the damage claimed, and I would allow this appeal. Similar in the judgment of Mrs. Lord Justice Hodgson and Lord Justice Sellers. My lord, the only paragraph that in Lord Justice Sellers' judgment, my lord, kindly come to the page, the next page, page 538. The paragraph at the top. The only question on this appeal is as to the damages the plaintiff is entitled to receive for the non-acceptance of the car by the defendant. The plaintiff claimed the loss of profit on the sale. The defendant denied that there had been any in the circumstances any profit lost and alleged that the nominal damage is only recoverable. Then next paragraph. The car rejected by the defendant was put back into the plaintiff's showroom and was sold within a week or 10 days to another customer at the same fixed retail price. This effective sale resulted in the normal profit to the plaintiff, but he claims that he has nevertheless lost a profit, for he would have sold and delivered, but for the defendant's default, 2 cars instead of 1, and would have made 2 profits instead of 1. This is the argument of Mr. Banerjee also. Having regard to the nature of this claim, singularly little evidence was directed to the issue. Then, my lord, next paragraph, I am not troubling your lordship. Next paragraph. A seller's loss of profit on the sale may clearly, directly, and naturally result in the ordinary course of events from a buyer's wrongful neglect or refusal to accept and pay for the goods bought. But it may be that the seller is so circumstanced that he could sell the goods elsewhere, either at the same price as the contract price or at some lesser price, which would either extinguish or minimize the loss to the seller, and therefore the damages which the defaulting party will have to bear and pay. Question of mitigation. Counsel for the defendant placed great reliance on 53. Then, my lord, I am not troubling your lordship because that was not available. Issue of available market was not, my lord, gone into. Kindly come to the next paragraph. No evidence was given as to anything the plaintiff might have done to bring about a resale of the rejected car, except that which he did, namely, place in his showroom and await a new buyer. Having regard to his success within 10 days, the submission on the meaning of available market seems to me to be somewhat theoretical and academic. So, my lord, 53 was not taken note of. My lord, the point is this, my lord. This is the issue of mitigation of damage. This judgment, my lord, is a judgment on the mitigation of damage. I have a car. I wanted to sell it to Mr. HON'BLE. He refused to take it. I was to sell it at, say, 500 rupees. I sell it to Mr. Shakoshen at 600 rupees. I make a profit of 100 rupees. My lord, can I, my lord, file a suit against Mr. HON'BLE and say that I have suffered loss? If I have not suffered loss, you will have to prove 2 things. First is liability to adhere to the terms of the contract. That is the first issue. Did you commit a breach? I have committed a breach. Let us say, assume that is being proof that I have committed a breach. The breach, because of the breach, I am not to be penalized. Yes, I am to be penalized if you have suffered damage. That is the contract. That is section 73. And for the purpose of showing that I have suffered damage, the person who is claiming damage, he will have to show, and that is what, my lord, what was pointed out by my lord on the very first day of Justice Umar Nayan, that explanation under section 73. What have you done for the purpose of mitigation? You should do what is reasonably expected of you to do. You cannot just sit with the thing which was to sell and say that I have suffered damage. You will have to show that you've tried to sell it to somebody else. And by selling it, you have sold it at a lesser price and therefore you have suffered damage. If you have sold it at a higher price, then why should you be, even though the person concerned has committed breach, why should you be allowed, should you be condemned to pay damage? If the person concerned who is complaining of the breach has not suffered damage. And that is why it says no evidence was given as to anything the plaintiff might have done to bring about a resale of the rejected car, except that which he did, namely place it in the showroom and await a new buyer. Having regard to his success within 10 days, the submissions on the meaning of available market seem to be academic. Then, my lord, kindly come to page 539. My lord, these judgments, my lord, I tell you, as I told you, lordship, I must frankly confess to lordship, when I read Mr. Abjohn's judgment, I was telling Mr. Sen also in confidence that it was going against my grain. I did not accept it straight away. I did not accept it. My experience in this profession, my whatever knowledge, my lord, I have acquired, my lord, it was militating against the judgment of Mr. Abjohn. So, my lord, I did my research. And this is, my lord, what I found. I shall give you a lot, my lord. Kindly come to page 539. Second paragraph. The plaintiff had the duty to act reasonably. This is, my lord, the explanation to section 73. The plaintiff had the duty to act reasonably and mitigate the damages as far as reasonably could. My submissions have been recorded here. What he did resulted in a resale at the contract price. But the question is whether that resale mitigated his loss. And the same question would arise if a sale could have been made in an available market. The plaintiff's case is that by reason of the defendant's non-acceptance of the car, he had bought the car he had bought, the plaintiff has lost the profit he would have earned, and that the resale of the car to another customer did not and could not, in the circumstances, give him a substituted profit. He claims that he could have sold a Hillman Minks to the defendants and another to the new purchaser and made two profits, whereas he has made only one and lost irreplaceably the profit on the defendant's transaction. This is exactly the judgment of submission of Mr. Banerjee. If a seller can prove that a profit has been irretrievably lost on a sale of goods by the buyer's default, it would, in my opinion, be recoverable as damages in accordance with section 50, subsection 2. But where there is in fact a resale of the goods, the seller has the burden of proving a loss of profit beyond that which on the face of it has been recouped in whole or in part by the resale. And the next sentence is important. In my view, the plaintiff has failed to give adequate proof of such a loss in this case. Well, I am adopting. This is my submission. My submission has been recorded in the form of a judgment. Well, this is exactly what I submitted. Well, kindly see, these judgments have been written in very felicitous language. Kindly come to next page, page 540. Lord Justice Seller's judgment. Second paragraph. The matter cannot, of course, be worked out ad infinitum, but would be decided on the probabilities of the case and having regard to the nature, extent, and circumstances of the dealer's trading. If a dealer has 20 cars available, the sale of 25 potential, if a dealer has 25 cars available for sale and the 25 potential buyers are, and 25 potential buyers, he still would make his full profit if he sold his 20 cars, notwithstanding that 2 or 3 of these purchases are defaulted. This is my submission. Well, I am not. I will request your lordship, my lord, to take note of this particular judgment. My lord, I did some further research, my lord. I don't know whether I should go on multiplying decision. One more decision I would like to cite before lordship. That is also, my lord, appellate court decision of the English court, High Court. This is, my lord, a decision of the. There is a decision of the Court of Appeal, my lord, in which, my lord, Lord Denning, Master of the Rolls, Lawton, and Lord Justice, these three were there, and they have delivered a judgment. But I find here there is a slight shift. Here, my lord, there was a single car, second-hand BMW car. After my lord reading this, now I am thinking of selling my BMW car. This is your lordship will kindly see. There is no, in this case, my lord, the judgment of my lord Charter and Sullivan has not been noted. But what has been noted is, my lord, this Thompson's case. Very short judgment, if I may just place it before your lordship. My lord, kindly take the facts first. This your lordship will please to find at page 460. Interesting, each case is interesting. This is, my lord, Placitum F at page 460. The plaintiff's Lazenby garages, dealers in second-hand quality cars, claimed against the defendant Alan Wright. তোমাদের copy দিয়েছি? Alan Wright, that by an agreement in writing on February 19, 1974, he had agreed to buy and accept from the plaintiffs on 1st March a BMW 2002 motor car for the sum of rupees 1,670 pounds. But of course, this price is, of course, not acceptable to me.
But may I, sorry, why should it be plaintiffs? After all, this is an English report. It's a limited company.
Yeah, that's right. My lord, this garages has been described as dealers.
Yes, but the plaintiff is Lazenby Garages Limited.
Right. It should have been a dealer in second hand. It should have been
plaintiff. What I am on grammar.
Yes, but I am on grammar too. My lord, kindly see, my lord, the plaintiffs, my lord, plural, Lazenby Garages Limited, comma, dealers in. So that is why, my lord,
anyway,
plural has come. Cards claimed against the defendant Alan Wright that by an agreement in writing so and so he had agreed to buy and accept from the plaintiffs on March 1 a BMW 2002 motor car for the sum of rupees 1,670, but that orally on 1st March he had refused to accept the motor car or to pay for it, as a result of which they had suffered 345 pounds loss of profit on the agreement for sale, and they claimed that sum as damages. The defendant admitted the agreement of February 19, but claimed that he had told the plaintiffs on February 20 that he did not wish to proceed with the purchase, and that subsequently plaintiffs had sold the same motor car to another purchaser at a price of not less than 1,670, so that in the premises the plaintiffs had not suffered any damage or loss. Justice Irwin, on December 16, 1974, gave a judgment for the plaintiffs for a sum of rupees 172.50, one half of the amount claimed and their cost. The defendant appealed on the ground that the judge misdirected himself in law, in that having found as a fact that there was on the evidence no more than 50-50 chance of the plaintiff selling another second-hand car at a profit. If the defendant had accepted the car they sold to him, he failed to direct himself that the plaintiff had not succeeded in proving any loss on balance of probabilities. 2, that he had misdirected himself in law in holding the measure of damage was not to be determined by reference to section 50, subsection 3 of the Sale of Goods Act. And 3, that he was wrong in fact in failing to find on the evidence that there was at the material time an available market in the meaning of section 50, subsection 3 of the Act. 4, that he was wrong in the fact and in law in failing to hold on the evidence that the reason of the application of section 50, subsection 3, the plaintiffs having resold the car at a greater profit than they would have gained from selling it to the defendant, had failed to prove any loss at all. 5, that he was wrong in fact of failing to find that any other second-hand car, or this was not necessary. Then, my lord, 6 is that he was wrong in fact and law in holding that because there was an equal chance of the plaintiff. My lord, this is also not necessary. 7 and 8. and this is also an argument which has been noted. The 7, kindly see 7, that he was wrong in fact in failing to find that no two second-hand cars which the plaintiffs had for sale were alike in sellability, and that there was no evidence that at the time of resale of the car, the plaintiffs had or could have had a comparable one which they might have sold to the eventual purchaser of the car, and the defendant in fact accepted, and that he was wrong in fact and law in failing to find the plaintiffs had under a duty to mitigate. Well, that he was, this is also important. 8 is that he was wrong in fact and law in failing to find that the plaintiffs being under a duty to mitigate the loss arising from the breach of contract by the defendant, in fact mitigated any such loss completely by reselling the car at a greater profit. Then, my lord, kindly come to the judgment of Lord Denning. A very short judgment. He says this: Mr. Wright works on the land. On February 19, 1974, he went to the showroom of motor dealers called Lazenby Garages Limited. He saw some second-hand cars there. He agreed to buy BMW 2002. He signed a contract to pay £1,670 for it. It was to be delivered to him on March 1, 1974. He went back home to his wife and told her about it. She persuaded him not to buy it. So next day, he went back to the garage and said he would not have it after all. They kept it there, offering it for resale. 2 months later, on 23rd April 1974, they resold it for £1,770. That is for £100 more than Mr. Wright was going to pay. Notwithstanding this advantageous resale, the garage sued Mr. Wright for damages. They produced evidence that they had themselves bought the car second-hand on 14 February 1974, that is 5 days before Mr. Wright had come in and agreed to buy it. They said that they had bought it for 1,325. He had agreed to buy it from them for 1,670 pounds. So they had lost 345 pounds, and they claimed that sum as damage. In answer, Mr. Wright says, you haven't lost anything. You have sold it for a higher price. The garage people said that they were dealers in second-hand cars, that they had a number of cars of this sort, of age and type, BMW 2002s, and they had lost the sale of another car. They said that if Mr. Wright had taken this car, they would have been able to sell one of those other cars to the purchaser. So they sold one car less and were entitled to profit accordingly. The argument is the same as the argument in the Thompson's case. The judge thought that they had not proved that they had sold one car less, but that there was 50-50 chance that they would have sold an extra car. So he gave them damage for half the sum claimed. Instead of 345 pounds, he gave them 172.50 pounds. Almost rule of the thumb. Now, there is an appeal to this court. The Lord Denning's judgments are so felicitous in language, it's really just like a story.
Exactly.
Now, there is an appeal to this court. The cases show that if there are a number of new cars, all exactly the same kind, available for sale, and the dealers can prove that they sold one car less than they otherwise would have done, they would be entitled to damages amounting to their loss of profit on the one car. See the judgment of Mr. Upjohn in so and so. Well, surprisingly, the other judgment had not been cited at all, referred here. The same has been held in United States and so and so. But it is entirely different in the case of a second-hand car. Now we come into the realm of second-hand car. Each second-hand car is different from the next. Even though it is the same make, the sales manager of the plaintiff admitted in evidence that some second-hand cars of the same make, even of the same year, may sell better than the others of the same year. Some may sell quickly, others may be sluggish. You simply cannot tell why, but they are all different. In the circumstances, the cases about new cars do not apply. We have simply to apply Section 50 of the Sale of Goods Act, Section 73 of our Act. There is no available market for second-hand cars. So it is not subsection 3, but subsection 2. The measure of damages is the estimated loss. The measure of damages is the estimated loss resulting directly and naturally in the ordinary course of events from the buyer's breach of contract. That throws us back to the test of what could reasonably be expected to be in the contemplation of the parties as a natural consequence of the breach. The buyer in this case could not have contemplated that the dealer would sell one car less. At most, he would contemplate that if they resold this very car at a lower price, they would suffer by reason of the lower price and should recover the difference. But if they resold this very car at a higher price, they would suffer no loss. Seeing that these plaintiffs resold this car for £100 more than the sale to Mr. Wright, they clearly suffered no damage at all. In my opinion, that appeal should be allowed, the judgment entered for the defendant. So, short and simple, apply Section 73, the principle which is contained there. Find out whether he has suffered any damage. Look into the evidence of the parties. If you find that he has not suffered any damage because he has sold it at a better price, then he is not entitled to any damage at all. My lord, Your Lordship, can you see Lord Justice Lawton? In the course of argument, Mr. Scannell, on behalf of the plaintiffs, accepted that if a dealer is selling an article which is unique, for example, if a second-hand car dealer was selling a vintage car, or if an antique dealer was selling a picture, then if there were a repudiation by the buyer of a contract entered into, the damage would be the particular loss which was sustained. The damage would be the particular loss which was sustained on the transaction and nothing more. Lord Delhi, Master of the Rolls, has pointed out when the goods are not unique but are mass-produced, different consideration may apply from those which apply when an article is unique. The problem in this case is whether second-hand car of the type with which we are concerned, namely BMW 2002, petrol injected, was a unique article. The evidence of the plaintiff's own sales manager shows that it was. He put the matter in this way: no one can say what makes a second-hand car saleable. It is same with new cars. Cars vary as to the date, mileage, sound of engine, wear and tear, upholstery, etc. Then, a few answers later, he said, in second-hand showroom, each car is different. In other words, he was saying that second-hand cars are from their very nature unique. In those circumstances, it seems to me that the Thompson type case has no application to the circumstances of this particular case. I agree that the appeal should be allowed. Then, my Lord, Lord Justice Bridge also looks at it from another point of view. My Lord, these three judges are looking at from three different points of view. With respect to him, he said, I agree with the judgment have been delivered, and I only add a few words. With respect to him, it seems to me that the judge fell into error in thinking that he would estimate what effect would have been caused to the plaintiffs dealing in second-hand cars if the car, which was the subject of the contract, had been taken by the defendant in accordance with his contractual obligation and not sold on to another buyer. He sought to estimate the prospects of those circumstances of other buyers having purchased another second-hand car from the plaintiff. To my mind, there was no basis for any proper inference as to what effect the plaintiff's trade would have been felt if the car in question had been sold and delivered to Mr. Wright instead of to the buyer, who in fact eventually bought it. Any consideration of that subject matter would, in my judgment, be pure speculation and certainly far too remote to be the subject of an estimate of loss in accordance with section 50 subsection 2 of Sale of Goods Act. That is, an estimate of loss directly and naturally resulting in ordinary course of events from the buyer's breach of contract, or alternatively, far too remote to have been considered as being within the contemplation of the parties at the time of the contract, so as to be recoverable damage under the second rule of Hadley and Baxter. I agree with the appeal should be made. So, my lord, these are the decisions which are there. So, my lord, I will submit to your lordship. Keeping this in mind, your lordship, my lord, kindly, I have got to take your lordship to some kindly see, my lord, the evidence. Just I remind your lordship, I have placed it before your lordship once. হ্যাঁ ওটা দাও দাও দেখি একবার দেখে নি দেখি আমার এখানে নেই কোথায় আপনার স্যারের জন্য কপি আছে দিয়ে দিচ্ছ
What age did Mr. Deepak Basu attain?
Lincoln Sin.
Age
95 plus.
95 plus. And he stopped coming to court about
2014.
14.
For about 11 years, he did not come, could not come to. Toward then, my lord, I used to visit him regularly. Toward then, my lord, he was bedridden. He could not move.
Where is his son located?
At the moment, my lord, he had been transferred to Abu Dhabi. In fact, my lord, he was in Pune, then he was in Bangalore, then my lord, now in Abu Dhabi, but he is now here. There's a remarkable man. My lord, I have known him for the last how many years? 60 years or so. If I tell you, lordship, the story, he was a quiet chap, always smiling. But his courage, unbelievable courage. After 5 years in bed, after the entire body has been ossified, he started, it's by reason of wrong treatment.
Wrong treatment?
Completely wrong treatment.
No accident or anything?
There was an accident and there was a broken hip bone. He was plastered up and the doctors diagnosed as bone TB. So in order to arrest that, he was gradually being plastered up body. When we first saw him, it was this much. Then the legs, then the chest. Then Dr. Ajit Basu, your lordship remembers Ajit Basu, famous surgeon. He came down and he was taken to see. He said that, what have you done? For 5 years he's been lying there. He should have been on the move, where there should have been physiotherapy and vigorous movement. You have completely, if you keep him like this for 1 or 2 more years, he would be completely like a mummy. So immediately it was cut open, and my lord, he was put into rigorous exercises and physiotherapy. In that way, I mean, when he was not being able to, my lord, I have seen him, he could not sit. So he sat for, he was doing his medical examination, he was studying medical in, I think, Arjikar Medical College. He shifted his gear. He went into, he started studying BA. He passed with distinction. He, my lord, was giving examinations specially on high stool like this because he could not sit. So he was standing and writing. He passed with distinction. Then he sat for LLB. He got first class first. And he went to Dr. P.N. Banerjee, who was the vice chancellor. He sent him to Dr. B.C. Roy. He went to Dr. B.C. Roy and said that almost thumping table that you must give me scholarship. I want to go abroad. So B.C. Roy could not get rid of him. So he sent him to Humayun Kabir, who was the education minister. He went to London. He went to New Delhi. Got a partial scholarship to travel to England for operation because there was only one man, Dr. Batchelor, who could do the. This is a history story. He went there all by himself in a ship for 15 days. I don't know. I asked him. I was there in London to receive him, and I asked him, "How did you manage? Who was putting on your garments?" He said, "My roommates." He could not wear his shoes. He could not wear his socks. They were helping, and with long crutches, full crutches. He went to London. He studied. He went. He went and saw Lord Denning. Lord Denning gave him certificate that he should be operated free of cost. Dr. Batchelor operated him free of cost. He didn't have to pay because he didn't have the money to pay. The operation was done, 8 hours operation. I happened to be present there. And then, my lord, he passed his bar final, got his second class, came back and joined his profession.
Remarkable.
Remarkable, absolutely remarkable. And he never said about himself.
We have both seen him, of course. I mean,
In fact,
Mr. Banerjee, Mr. Justice Rai has also seen him.
in fact, my lord had occasion to appear with him several matters because it used to be very extensive briefed not by T. Banerjee and Company. I remember I've also not worked with him. But I was not aware of this side of.
No, I also.
And he always had a smile on his face, always with some kind of.
He had no enemy. I told him that. I said that, what kind of a man are you? You have not created any enemy in your life. Everybody used to love him in the family. And also in the profession. No, Baba, peculiar though. And even on the bed, he was smiling all the time. And he used to say, I have not lost my memory. You know, I remember everything. I can argue a case. Only thing I can't stand. Mr. Hirak Mitra used to visit once in a while. I used to go there regularly. But he gradually, so to say, he gradually sort of
faded away. Yeah.
Phenomenal chap.
Some altercations.
Yes.
Pre-COVID.
Pre-COVID.
After COVID, Malad, I don't think he could do anything.
I have been there pre-COVID. Mr. Banerjee was also on the other side.
Yes.
Jodhpur Park.
Jodhpur Park.
He had a garden house in a place called Horidepur or something.
Yes.
That long time.
In fact,
there were juniors went there.
Once, yes, correct. We had one of the. It invited all of us, the juniors.
ওটা কি জানো বাংলাদেশে কি কোথায় জায়গাটা কি নাম ছিল
হরিদেবপুর
Yes.
Malad, the last decision that I would Well, I want to come back to India. We have cited the English judgments. This is a judgment of the Kerala High Court. But the judgment has been delivered by a bench consisting of two learned judges, both of whom went to the Supreme Court afterwards. It was 1985, AIR 1985, Kerala, page 262. It's a short judgment. I only give your lordship the section 56 of the Sale of Goods Act has been referred to, and reliance has been placed on Hadley and Baxendale. Your lordship kindly takes the facts, my lord. The defendant in a suit for recovery of money is the appellant. The first plaintiff is the National Textile Corporation, and the second plaintiff, Vijay Mohini Mills, is one of the units of the first plaintiff in the virtue of Sikh textile undertaking. Exhibit A1 and Exhibit A2, evidence of a contract of sale between the second plaintiff and the defendant, under which 15 bales of 40s and 25 bales of 60s of the cotton yarn had been sold by the plaintiff number 2, the defendant. As per the terms of the contract of sale, the goods were dispatched by plaintiff 2 to the Calcutta branch of the defendant on 22/1/1975, and the relative documentary. Since the defendant did not take paragraph 3, so the defendant did not take delivery of the goods, Exhibit A6, notice dated 17/6/75 was sent by the plaintiff number 2 to the defendant. In that notice, plaintiff number 2 specifically stated that unless the goods were immediately cleared by him, it would take steps to for sale of the goods, and the defendant would be held liable for all consequential loss and damages. In reply to Exhibit A6, the defendant sent A11 letter dated 8/7/75, totally denying liability or responsibility on his part for the goods dispatched by the plaintiff number 2. He even questioned the very existence of the contract, since the defendant refused to act upon the up to his obligations under the contract. The goods were sold by the plaintiff number 2 on 27/9/1975 to yarn distributors for the best available price to the market. As a result of the sale, plaintiff number 2 incurred a loss of Rs 50,000 so and so, which includes the difference between the contract price and the price realized by sale, as well as the lorry charges, commission, demurrage, etc. Plaintiff number 2 caused a suit notice dated so and so to be sent. Exhibit A12 dated so and so is the reply notice. The suit was accordingly instituted for realization of Rs 50,445. Then the exhibits have been referred to. Books of account of the plaintiff number 2 was proved. Then, my lord, the defendant in written statement questioned the existence of the contract, the genuineness of sale, etc. Then, my lord, kindly come to the evidence has been discussed here. Paragraph 6, the Balakrishnan appearing for the appellant submits that there is no reliable evidence to support the alleged sale at Calcutta. We do not agree. Exhibit A13 is the books of account regularly maintained in the course of business by the plaintiff number 2, which is the nationalized company. The relevant entries in the account books have been spoken to by plaintiff number 1, who is the accountant. This is perfectly reliable evidence. We do not see any reason to suspect the genuineness. Then section 56 of the Sale of Goods Act has been quoted, which is very simple. Where the buyer wrongfully neglects or refuses to accept and pay for the goods, the seller may sue for the damages for non-acceptance. A simple sentence it is. And then, my lord, this, by reason of this, section 73, 74, all these sections are invoked. The measure of damages has to be determined with reference to the rule in Hadley and Baxendale, reported in 1854 9 Exchequer, which is incorporated in section 73 of the Contract Act. The section reads where the contract has been broken, etc. It is not necessary to read the rest of the section, as we are concerned only with the first rule in Hadley and Baxendale. That rule postulates compensation for any loss or damage which naturally arises in the usual course of things from the breach. The measure of damages for non-acceptance is the estimated loss directly and naturally resulting in the ordinary course of events from the buyer's breach of contract. The general intention of the law is that in giving damages for breach of contract, the party complaining should, so far as it can be done by money, be placed in the same position in which he would have been had the contract been performed. Where there is an available market for the goods in question, the proper measure of damage is prima facie to be ascertained by reference to the difference between the contract price and the market or current price at the time of the breach. If, however, the market rate on the date of the breach is not available, it is open to the court to take into account the surrounding circumstances and the evidence regarding the rate, the market rate, the market on which the subsequent dates with a view to awarding proper damages in terms of Section 73 of the Act. The principle is founded upon general duty of the seller to mitigate the damage by taking all reasonable steps to minimize the loss. The seller must, therefore, take reasonable steps to sell the goods for the best price that he can obtain. The difference between the price for which he sold the goods and the contract price is the true measure of damage. Where there is no evidence as to the market on the date of the breach, and where there is evidence as to the market for the goods in question on any subsequent day, it is the rate prevalent on the subsequent date that would be relevant for the purpose of determining the measure of damage. All that is expected of the seller is to act as reasonable men and take reasonable steps to minimize the loss. In the present case, Exhibit A1 and A2 leaves no doubt that the plaintiff number 2 and the defendant had entered into a contract of sale wherein the goods were dispatched to the second plaintiff in Calcutta. It was the duty, by the second plaintiff to Calcutta. It was the duty of the defendant to honor the contract and promptly take delivery of the goods at Calcutta. He failed to do so. The goods were not immediately sold because the plaintiff number 2 urged the defendant by means of a letter, telephone request, and telegrams to take delivery of the goods. Due notice was issued. Then due notice was issued to the defendant on 17/6/75, informing him that if he did not take delivery of the goods, they would be sold at the risk and cost of the defendant. Plaintiff number 2, in the circumstances, acted most reasonably, took prompt steps to mitigate the damages. The defendant is liable to compensate the plaintiff number 2 for the loss suffered by it as a result of the sale. The true measure of compensation is the difference between the contract price and the price at which the goods were sold. Finally, sold in Calcutta and incidental expenses. The court below accepted the claim. We see no reason to interfere with this. So, my lord, this does not say anything more than Section 73. And, my lord, the principle of mitigation has again been reiterated.
Mr. Banerjee, MV Elizabeth, you would remember?
Yes, just comment.
Justice Thoman, no?
Went from here, my lord, to.
Yes.
I was just thinking about that.
Correct. Sorry.
1990 Supreme
93 Supreme
93 Supreme
Court.
10141.
The page number?
Elizabeth.
Because both of us, I think, dealt with that case 200 times or even more.
Admiralty
Admiralty.
changed really the law with just put in other. I was just thinking about that, just the comments.
So, my lord, this brings me to just to refer your lordship to yes, my lord. I will request your lordship to keeping this in mind, my lord. Kindly take two documents just, my lord, to support my submissions on the basis of the law that I have submitted before Lordship, kindly, my lord, take the. I think it will be easier for your Lordship to, instead of handling the thick volumes of my lord, the evidence which has been raised, my lord, kindly take, my lord, the notes of argument on behalf of the appellate. That, my lord, contains some of the. Your Lordship kindly takes this. This is আচ্ছা আছে এইটাই তো এইটাই Well, kindly take, well, this is annexure, this is the exhibit EQ. It's annexure, right? The exhibit EQ, page 33, kindly take. For the sake of convenience, well, they have been annexed.
Chrysil.
Yeah, Chrysil report. I am not going to trouble your Lordship with this, the entirety of. Kindly come to page 36 of this. Page 36, my lord, towards the bottom, presence in an industrial belt with high energy demand. GECL's operational Raniganj South Block is situated in the vicinity of the Asansol Raniganj Durgapur Industrial Belt. GECL's in my land friend. These cities have industrial activity with significant fuel demand, such as steel plants, carbon black, glass and chemical industries. Prominent companies in the vicinity include ISCO Steel Plant, Durgapur Steel Plant, Alloy Steel Plant of SAIL, besides Alstom Projects, Graphite India Limited, and Philips Carbon Black. As of March 2013, the company had aggregate commitments to purchase 402 mm SCM of CBM, as against 80 mm CBM of production in financial year 13. Then expansion by sale to augment demand. This is again, well, I am showing your Lordship that the demand was there for the gas. And well, this Chrysil report is, well, their document, which I produced and tendered. Is the report on their performance. Then, my lord, next paragraph. Expansion by sale to augment demand. SAIL steel plants in Asansol, Raniganj, Durgapur belt are expanding, which should increase demand for gas in the area, as the new units are designed to use gas as fuel. For instance, SAIL ISCO, a customer of GGCL with gas offtake of Swenso, is one of the biggest steel players in the region and has undertaken an expansion plan of Swenso billion on this in the sellable steel capacity. Post-expansion expected to be completed by July. Gas requirement is expected to rise by 146. Similarly, Alloy Steel Plant of SAIL has entered into MOU with Kobe Steel of Japan to set up Swenso. Lower competition in the region and the fact that gas is cheaper than other substitute fuels. Gas availability in the Asansol, Raniganj, Durgapur belt is currently low, as the development of awarded fields to players such as ONGC, SR Oil, and RIL had been slow. Thus, for the past 5 years, GECL's Raniganj South Block has remained the only commercially producing CBM block catering to the industrial belt. Even the supply of natural gas from other gas producers such as RIL, KG Basin Swenso, ONGC, KG Basin Swenso, GSPC, KN India, Oil is expected to be minimal because These players have minimal surplus gas to sell, and there is no existing pipeline grid network that can serve the Asansol Durgapur region. Then, my lord, kindly come to page 38. Point out gas demand to grow at CAGR at 6.6% over the next 5 years. CAGR is compound annual growth rate at 6.6%. India's natural gas supply has trailed demand in the past 5 years, with consumption growing at 5 years CAGR of 6.6% to 57,670 MMSCM, and domestic gas production grows at a lower CAGR so and so, and is expected to rise at 20% by 2025, implying opportunities for domestic producers to meet the rise in demand. Moreover, as natural gas is cleaner fuel, easy to manage and transport, and has higher calorific value than coal, it is more acceptable as energy source by the industries such as food processing, automobiles, carbon black, etc. Then, my lord, kindly see this chart, these bars at the bottom. I don't know in what it's a black color, but it should be in some color, my lord. It is not there. But, my lord, kindly see from 2010 onwards how, my lord, the demand has gone up, and deficit met through LNG imports and the total supply. This is there, and, my lord, it has gone up to 213. But we do not know which is production and which is deficit, because these the colors are not available here. Well, this is one thing I wanted to show to your lordship. And, my lord, this is an and and kindly note this, the year here is up to 2018 it has been given. It is not that it has stopped in 2013 in the crisis report. Then, my lord, at page Annexure E, which is Exhibit ER, page 47. Wait, 47. Page 41. Is your lordship this particular document page marked? Page 47. It is Annexure ER, the next one.
Yes.
Kindly see, my lord, the last paragraph of that page. The exhibit here. These are exhibit exhibit number. This is exhibit. It should not be annexure here. It should be exhibit here. And these are concerning, my lord, the plaintiff. Kindly see credit risk assessment, the last paragraph. The total income increased by approximately 30% during financial year 2014 on account of 25% increase in volume of gas sold. Your lordship has got that? And better sales realization, so and so, as against 21.51 SCM as against 20.85 SCM, refers to the period April 1 to March 31. The realization improved primarily on account of favorable demand supply scenario. PBILDT, that is, my lord, profit before interest, lease, depreciation and taxes. Margin witnessed improvement of 500 BPS during financial year 2014 to 69.11% as against 63.98% during financial year 13 on account of increase in operating income, absorbing higher capital cost. Then GECL's PAT is profit after tax, turned positive in financial year 2013 and has doubled since then. During financial year 14, the company reported PAT, that is profit after tax, is 77.61 crores, leading to PAT margin of so-and-so as against PAT of so-and-so. Well, what I am on is this, that these were there before. Why is it that these were not taken note of? These were not taken note of. The court, my lord, I shall show to your lordship, and this is where what I'm questioning.
There's absolutely no reference in the award.
No, I tell you actually why. The tribunal, kindly see, my lord, that portion of that. Kindly see this portion of the award. Award কপিটা কোথায় গেল আমার? আরে ওই তো আমার একটা ভলিউমে রয়েছে। মানে kindly see this, I think it will be clear.
Mr. Mithru, you'll continue at 2 o'clock?
Your lordship, so desires, yes, sir.
No, whatever you want.
I think I shall try and go as fast as possible, since my lord, your lordship is on this.
Yes, so let us conclude at least your.
As far as I can go, at least.
চলো ঘুরে আসি।
যতক্ষণ পারি করি, যতক্ষণ দাঁড়াতে পারি, দেখি না কতদিন দাঁড়াতে পারি।
Wish we could have your strength at your.
No, if you want to, if you.
No, absolutely no. Because of my age, do not give any latitude to me.
No.
I always request to everybody, including my wife. I said that don't.
But even we.
We all wish that we can have
exactly
his strength
that
and
strength.
Absolute touch wood. We all.
We will come back at 2 o'clock.
Great.
Till 3:15.
Yes.
Till 3:15. Anyway, we'll rise.
There's a full court.
We'll actually rise at 3 o'clock. There's some other work before that.
Very well. Lord, if Mr. Mitra finishes, Lord, this Friday, Lord, I have some difficulty.
You tell us
But
whenever.
Lord, Monday, Lord, if it's.
You shouldn't be taking long.
No, I won't
rejoin
now, Lord, there are 3 new judgments which have come, Lord. I just want to show, Lord, why, at least my effort to show why it's not relevant. So. Well, it's speaking, Shalom.
Sorry, my lord.
No problem, Mr. Mr. The condolence meeting, we understand.
So I was weak. Well, the only other thing before I take your lordship into your lordship has been pleased to put me a very pertinent question, whether this evidence was at all considered or not. I shall come back to it, my lord. Your lordship will please to come to notes of argument. Well, Lord, kindly come to the notes of argument once more. Just one thing I wanted to show. একটা কোথায় 47 তো দেখালাম my lord, kindly come back to my lord. ওটা ছেড়ে দাও কেয়ার রিপোর্টটা কোথায় Well, kindly come to page. This is Skychill I've shown to your lordship. Kindly come to care report. Page 47. I'm দেখাচ্ছিলাম তো page 47. Kindly come to page 56 of the argument. Well, this is care rating. This is also of GECL, the claimant. These reports are all of theirs, produced by us, but these are concerning, my lord, the claimant. Page 56, your lordship has got that. Say, kindly see competition. The first paragraph. As per Director General of Hydrocarbons, my lord, we have given the report also. This has also been filed as our evidence. There have been 33 blocks awarded under 4 rounds of CBM till March 31, 2015, out of which 3 blocks have been proposed to be relinquished by the operators. However, only a few players are actively pursuing the CBM interest currently. GECL faces competition from SR Oil, which is also an active participant in CBM business and has license for Raniganj East Block. Production so and so. The risk is mitigated to an extent as EOL has signed 20 years gas supply agreement with Matrix Fertilizer and Chemicals for supply of CBM gas. Matrix Fertilizers Chemicals Limited gas requirement is around 2.5 mm so and so of 100% capacity. Then traditionally CBM gas has competitive advantage over the alternative fuels on account of its pricing. However, with failing oil prices globally since last 1 year, the advantage has narrowed down. Going forward, the impact of any further decline in oil prices remains to be seen. However, this is important also, the risk is mitigated to a large extent as the Asansol-Durgapur belt is a gas deficit region expected to increase even further, and there exists huge requirement of gas by various companies. And the prospects have also been given. Kindly see the financing performance of GECL. Working result 2013 158.18 net sales, 2014 203.79 net sales, and 2015 net sales to 227.33. And total operating income has correspondingly gone up. So these were all being shown for the purpose of my lord establishing that there was a tremendous demand for gas because the number of suppliers was less, the demand was more. So that was thought to be well, kindly in this connection kindly come to page 80 on that very volume. Extract from the cross-examination of RW2, our witness, by Mr. Banerjee. 42, question 42. Come to anesthesia EQ, which I have shown to your lordship, and ER, this crisis and care, of your affidavit evidence. Have you prepared any of these reports? Answer is no. Anesthesia EQ is prepared by crisis and anesthesia ER is prepared by care. These reports are prepared as per the instruction of the claimant. This claimant's requirement, and they were prepared. Only my client produced it. Therefore, my lord, by tendering the document, I can say that you can rely upon the statements contained there. I mean, the only thing that could have been done is cross-examining my witness on this. Then, my lord, 43.
These reports were prepared in connection with some IPO. An IPO.
Yes.
Red herring prospectus, my lord, which that's my lord, what the evidence is.
These are, I am proceeding on the basis that these are credit rating agencies who have made statements on the basis of records of the claimant itself. That is what, that's all that we have been. And my lord, this could have been, these are evidence which are on record. The evidence has gone in. So what was expected was that the tribunal to take consideration of that. That could have been the tribunal could have come to the conclusion that this evidence has got no value, or whatever it is. That was not done. Then 43. Did the claimant tell you that these reports have been prepared on their instruction? The witness goes through the document and say EQ and then answer. These reports are prepared for investors and stakeholders of GECL, and both CRISIL and CARE are the credit rating agencies who provide their services on the basis of payment for their clients like GECL. Then 44, did you have anything to do with the preparation of any of this EP or EQ and ER? Answer is no. In fact, my lord, after these documents have been tendered in evidence, my lord, the claimant could have proceeded on the basis that these are admitted documents. Now these documents have been admitted, could have cross-examined or could have, my lord, relied upon it, or could have done something or the other of their choice. And then 47. EP, EQ, then my lord, 47. So the answer is, what about annexure ET? Did you have anything to do with the preparation of this annexure? I have downloaded these documents from the claimant's website portal. So these are claimant website portal. These documents have been. Now, my lord, kindly see this document. Page of 83. 19. 12, 19. But kindly come to page 83. But this is cross-examination of the claimant's witness. And question 218. Is the gas production by the claimant in excess of what the claimant's clients required for supply? I have already mentioned that CBM production is a continuous process. CBM gas once produced cannot be stored, and if not consumed, to be distributed, not to be
flared.
Yes, flared.
Claimant
tries to increase in production on continuous basis, the increased production will. Why does the claimant, according to you, continuously strive to increase the production of CBM gas? Is it because the demand for supply of CBM gas has been increasing continuously? Answer is, claimant needs to adhere to the commitment that it made to the government as well as to the contracted customers. So, this is an admission that there had been an increase in requirement of the gas. How many customers does the claimant have in the minimum guaranteed offtake commitments? I need to check. Has there been any unusual increase or decrease in the flaring of gas by the claimant at any time in 2015? There has been flaring of gas in the year 2015. I am not aware of the exact quantum of flaring. As a senior officer of the claimant, would you not have been aware that there has been an unusual increase and decrease in flaring of gas at any time during the year? Flaring numbers are reported by separate department, which in no way related to the marketing that I am concerned with the department. Which department is concerned with the flaring? Production and operation. Then 225 at page 85. Was the flaring of CBM gas at any point of time during the year 2014 more than that of the corresponding period in 2013? I am not aware of the quantum of flaring in 2013 as well as 2014. but there was a flaring in the year 2013, also to some extent, also there is a flaring in the year 2014. Then 226. If I put it to you that flaring of CBM gas during 2014 was never in excess of the flaring of CBM gas during 2013 by the claimant, would you be able to dispute that? I have already mentioned, I am not aware. Now, my lord, kindly take the award. Since your lordship, my lord, wanted to see, kindly, my lord, take the award. I kindly come take paragraph page 84. Paragraph 212 is with regard to the report of the CCI and, my lord, the finding of the appellate tribunal and the High Court. They say that these are says it goes without saying that if civil court cannot question the finding of the CCI or the appellate tribunal, this tribunal is also unable to do so. So, my lord, this is, I am not going to question this. They said that the CCI findings cannot be questioned by the tribunal. Very well. Then, my lord, kindly come to paragraph 214. This is where, my lord, the shoe pinches. This arbitral tribunal has to decide the case of the parties on the basis of statement of claim and defense. Section 23 of the Arbitration and Conciliation Act provides that the claimant shall state facts supporting his claim, and the language is the points at issue and relief or remedy sought, and the respondent shall state his defense in respect of these particulars unless the parties have otherwise agreed. So, my lord, the claimant will have to state the facts supporting his claim and the points at issue and the relief, and the respondent shall state his defense. Respondent, I shall show to your lordship, has specifically denied and disputed. This has not been noted. I shall show to your lordship. Kindly now, come kind to page paragraph 215 at page 85 of the award. Following the aforesaid legal position, this tribunal has to decide the claim of the claimant on the basis of pleadings between the parties. The respondent, in course of his argument, sought to urge on the basis of the written notes, part 4, that the claimant had not suffered any loss by way of flaring up. And they have referred to returns filed by the claimant with Director of General Hydrocarbon, Ministry of Petroleum and Natural Gas. But in its SOD, Statement of Defense, the respondent has neither referred to nor disclosed these materials. My lord, as you are saying, my lord, but in the statement of defense, the respondent had neither referred to nor disclosed these materials. I was just wondering, my lord, am I supposed to disclose these materials in my statement of defense? I am to, my lord, deal with what the claimant has urged in terms of section 23. With regard to, my lord, these are the things. Supporting his facts, supporting his claim, what do you say with regard to that? The points at issue, what do you say with regard to that? And the relief or remedy sought. And the respondent shall state his defense in respect of these particulars. So, my lord, if it is found that the facts supporting the claim or the points at issue and the relief or remedy sought had been disputed and denied, well, I respectfully submit the issues arise on that issue. And on that issue, the court had to decide. One doesn't have to say that I am going to rely upon X, Y, and Z things. And particularly when you have not mentioned, my lord, you have not raised any issue. I would have thought that the tribunal should have raised the issues, because the issues are facts. With regard to damage, is a pure question of fact. And I shall show to your lordship on the basis of the averment in the paragraphs 82, 83 of the respondent's statement of defense, dealing with paragraphs 46, 47, 48, 49 of the statement of claim. There are clear, my lord, issues which could have been raised with regard to, my lord, the claim. But it is not that we are admitting the claim. It is a dispute. I mean, I should say, my lord, it's an intense dispute between the parties. And, my lord, not a small amount of money has been claimed against us. Who is such a fool as not to contest that? And they have contested that. And the learned arbitrator tribunal has said, but in its SOD, the respondent has neither referred to nor disclosed these materials. It is well settled that the facts on which there is no pleading, no evidence can be adduced. Even then, it shows from the chart produced by the respondent that there is flaring up. This tribunal is unable, for the reasons discussed above, to accept the respondent's attempt to contradict the finding of CCI that GCCL had to flare up 28.48% of the gas produced in 2015-16, as it had no market for the same after the respondent terminated the contract in July 2014. So, an attempt to contradict the finding of CCI. What is the finding? 28.48 flaring up. This has become the bone of contention. This is the foundation on the basis of which, my lord, my defense has been totally denied. I say that this is where it has gone wrong. Well, if I tell you, Lordship, very frankly, if this evidence has been considered and the tribunal had come to the finding that these are not materials on which reliance can be placed, assessment of evidence, then, my lord, by reason of the various judgments cited, perhaps I would have been out of court. It is within the jurisdiction of the arbitral tribunal to assess the quality and quantity of evidence. And once that assessment is made, then, my lord, the court says that by reason of the provisions of the Arbitration and Conciliation Act, the court should not sit as a court of appeal and reopen the whole issue. And, my lord, apropos that, the jurisdiction of the appellate court has been restricted. But first of all, the foundation has to be there in the trial court. Then only, my lord, the question of whether the appeal court can go into the issue or not has to be decided. My submission before the court is this: if the tribunal has, my lord, has not taken note of the relevant evidence which has been produced before it, and the tribunal has not come to the conclusion that this particular evidence is not acceptable, assessing the evidence, then, my lord, I respectfully submit that the decisions which have been cited on behalf of the claimant perhaps can be distinguished and can be said has got no application in the facts of this case. This is what I wanted to submit to your lordship. Then, my lord, kindly see paragraph 216. The respondent has also relied on the judgment of Supreme Court in Kailashnath, which I have cited. In that judgment, the learned judges of the Supreme Court held in paragraph 33 that section 74 of the Contract Act is sandwiched between 73 and 75, which deal with compensation for loss and damage for breach of contract, which a party may sustain through non-fulfillment of the contract, after such party rightfully rescinds such contract. The court held compensation is payable for breach of contract under section 74 only where damage or loss is caused by the breach. Relying on the aforesaid observation, the counsel for the respondent urged that in this case, the claimant has not suffered any loss. Specifically, my lord, the argument had been made. What is the court's observation? Compensation is payable for breach of contract under section 74 only where damage or loss is caused by the breach. And, my lord, contention was made that you have not proved any damage or loss. Relying on the aforesaid observation, the learned counsel for the respondent urged, in this case, the claimant has not suffered any loss. But such a contention is clearly contradicted by the factual finding of CCI that GECL had flared up 28.48%. So, my lord, my entire contention is negative on the basis of a alleged factual finding, which is actually not a factual finding. So then what remains?
Does not confirm this finding.
I am, my lord, concerned with what the arbitrators have said. The witnesses' evidence has been taken note of or not, that your lordship will please to decide. Here, my lord, there is not a whisper with regard to evidence. There is not a whisper with regard to what has transpired by way of evidence. My lord, all this exercise which had been undertaken by the parties, my lord, leading evidence, CW1, CW2, RW1, RW2, RW3, RW4. I mean, some sort of reference should have been made. Perversity is what? My lord, this is the very learned judges, my lord, man the tribunal. So I should not, and in fact I am not going to, my lord, make any aspersion or any allegation against them. But I say that, my lord, legal perversity is writ large in this award. First of all, has relied upon as evidence, which is not evidence. Secondly, the evidence which has been led had not been considered on the specious plea that this is not in consonance with Section 23 of the Arbitration and Conciliation Act. Thirdly, the arbitrators have gone on the basis of and has awarded damage going on the basis of a formula without any foundational fact laid for it. One has to say that you have suffered damage. And you have to come to that conclusion on the basis of you negative, my lord, the evidence which has gone in. You say that, no, this evidence is not reliable. Therefore, I am not going into this evidence. I am not going to rely upon this evidence. And therefore, I am saying that 15% on the total amount of the total quantum of the value of the gas which could have been supplied up to 2034. No, but before you do that, and these judgments, my lord, which I have cited before lordship, which my learned friend has cited before lordship, every judgment says damage will have to be proved. Breach of contract causes damage, but the damage is quantified before the arbitrator, before the court, and that the court is entitled to see or assess. It is not, my lord, if I may respectfully submit, so to say, reopening the question which has been decided with the arbitrator. I am, my lord, urging before the court that what the arbitrator had not done is something which goes to the root of the award. And if the arbitrator has come to a finding without, my lord, going into the facts which had been laid before the arbitrator, I could have understood, my lord, if no evidence had been laid. Evidence has been laid, and each of these decisions which I cited, the English and Indian, they say that you'll have to prove damage. Breach only gives you an entitlement. Assessment of damage give you the relief. One is, my lord, the ascertainment of liability, and the other is quantification of liability. If the quantification of liability does not take place, then, my lord, award cannot be sustained. This, in fact, my lord, in short, this is exactly what I thought the Sanyong's case has said. Kindly see, my lord, Sanyong's case. They have cited that. Sanyong's case is at page 176. Sanyong's case, my lord, reported in 2019, 15 Supreme Court cases, page 131. And there, I only refer your lordship, my lord, to the relevant paragraph. না না আপনাদের রয়েছে আমার ইয়েতে দেখো দেখো তো আমার যেটা ভলিউমের এটার মধ্যে দেখো তো রয়েছে কেন হ্যাঙ্গিংটা আমার মার্ক করা রয়েছে হ্যাঙ্গিংটা আলাদা রয়েছে give me 1 second minute last one no kindly give me 1 second well, let kindly come to paragraph page 215 of the volume. My decision cited by my learned friend.
Page 215.
215 of this this thick volume that they have my lord filed by way of their evidence. 58. Volume 2. Volume 1.
Page 58. 58 of.
Oh, my lord, your lordship has got only one volume. I have got many volumes.
Two volumes. Volume 1 is my lord, page 58.
Correct.
Page 58. এটা কোন ভলিউম এটা?
ভলিউম 1 এটা হলো এপি অরিজিনাল যেটা দিয়েছিলাম না ওটা।
এটা পেজ কত বললে?
58 স্যার।
না না আমার তো
আমাদের ওটা থেকে প্যারাগ্রাফ নাম্বার দিয়ে
আমার মনে হয় সেটাই ভালো। Your lordship will kindly take this. Your lordship has got the copy. Kindly come to paragraph 37. In so far as domestic awards are made in India are concerned, an additional ground is now available under section 2A, added by the Amendment Act of 2015 to section 34. Here, there must be patent illegality appearing on the face of the award, which refers to such illegality as goes to the root of the matter, but which does not amount to mere erroneous application of the law. If it is erroneous application of the law, that is not good enough. In short, what is subsumed within the fundamental policy of Indian law, namely the contravention of the statute, not linked to public policy or public interest, cannot be brought in by backdoor when it comes to setting aside an award on the ground of patent illegality. Secondly, it is also made clear that reappreciation of evidence, which is what an appellate court is permitted to, cannot be permitted under the ground of patent illegality appearing on the face of the award. So, my lord, if it is not appearing on the face of the award, the court cannot reappreciate the evidence which has been appreciated by the arbitrator and reopen the issue. Then 39. To elucidate para 42.1 of associate builders, namely a mere contravention of the substantive law of India by itself is no longer a ground available to set aside an arbitral award. Para 42.2 of the associate builders, however, would remain, for if an arbitrator gives no reason for an award and contravenes section 31(3) of 1996 Act, that would certainly amount to a patent illegality on the face of the award. I pause here for a moment. This particular sentence I am relying upon. If an arbitrator gives no reason for an award, kindly put it this, if an arbitrator gives wrong reason for an award. For example, if this is not an evidence and the arbitrator proceeds on the basis that it is an evidence, then, my lord, can it be said that he has given reason for the award? I am asking this question to myself. What is the meaning of this? If he gives no reason for an award, but if he gives one wrong reason, I mean, especially wrong. I say that the arbitrator said that this particular color is red. Actually, it is the color is black. And your lordship comes to the conclusion it's a black color. Can it be said that it is a reason which has been given which is unassailable, cannot be looked into by the court, cannot be reopened by the court? The change made in section 28(3) of the Amendment Act really follows what is stated in para 42.3 245 in associate builders, namely that the construction of the terms of a contract is primarily for an arbiter. I am not troubling your lordship. I am omitting this particular paragraph. Then 41 is important. What is important to note is that a decision which is perverse, as understood in paras 31 and 32 of the associate builders case, while no longer being a ground for challenge under public policy of India, would certainly amount to a patent illegality appearing on the face of the award. So, my lord, if a decision is perverse, it is still open to challenge, may not be under public policy of India, but, my lord, on the basis of patent illegality. Thus, a finding based on no evidence at all, or an award which ignores vital evidence. My lord, kindly read this, my lord. I submit that this is my submission. I mean, I'm not going anywhere else. Thus a finding based on no evidence at all. 28.47 is no evidence, or an award which ignores vital evidence, the evidence which we have led. Cross-examination has been made. Extensive hearing had been conducted. In arriving at its decision, would be perverse and liable to be set aside on the ground of patent illegality. My submission is based upon paragraph 41. This is, my lord, what associate builders, my lord, earlier decision has said. Exactly the same thing. And that rightly, that is what, of course, sanctity should be attached to an arbitral tribunal's finding, arbitral tribunal's judgment, because the court would like to have a finality in the litigation, and that is the purpose of Arbitration Act. But, my lord, not to the extent of going and saying, my lord, that even if there is injustice, even then the finality in the arbitrator's award should be attached. Can it be said that when the court finds, court before which, my lord, an award comes for consideration, the court finds that there are findings in the award, there are statements in the awards which is contrary to records, or which ignores vital facts, can the court say that I shall shut my eyes to it and sustain that award? After all, it is for the purpose of doing justice between the parties, the Arbitration Act has been formulated, has been brought into existence. As the saying goes, my lord, quick justice is good, but good justice is better. My lord, the dispute resolution method is for the purpose of, after all, my lord, what is an arbitration? It is, my lord, two parties mutually agreeing to a named arbitrator, or to an arbitrator consented to by the parties. Why is it so? So that both parties can go away satisfied that our chosen selected arbitral tribunal had done justice to me. Claimant will think that way, respondent will think that way. If that purpose is not served, I submit to your lordship, my lord, the purpose of arbitration is not served at all. For the purpose of quick disposal, there cannot be, my lord, a travesty of justice. This is, my lord, what I am submitting to your lordship. In the facts of the instant case, this is what has happened. Keeping, my lord, my submissions in mind, I would request your lordship to look into the judgments which have been cited by the parties. This is my fundamental submission before lordship, that the court has ignored my evidence, or evidence, my lord, led by us on the basis of, my lord, arbitration, on the basis of, my lord, statements and counter statements. My lord, that has been ignored by the court on the specious plea that I have not pleaded it. Let us look and see, find out whether we have pleaded it or not. Kindly take, my lord. I shall just want to, on this aspect of the matter, before I take your lordship, my lord, into the judgments, kindly, my lord, look into the statement and counter statement. Why is it, I am just asking this question to myself, why is it the court has said this? Why is the court has said in paragraph Your Lordship, kindly come to paragraph 213 of the award. Is it correct? 213 and 214, my lord, one following the other. 213 is, as against the aforesaid case is, my lord, with regard to the justifiability of the MGO clause or sustainability of the MGO clause. 213. As against the aforesaid case made by the claimant and its unpaid MGO bills in paragraph 48, 52, and 53 of SOC, the respondent, while dealing with the aforesaid paragraph in SOC, in para 83 of SOD, did not dispute the MGO bills were raised by the claimant even after alleged termination of GSPA by the respondent. Apart from that, in para 83, there is bare denial by the respondent of the case made out of the MGO bill by the claimant in para 48, 52, and 53. And on the basis of this, the court is coming to this finding at paragraph 212. This arbitral tribunal has to decide the case of the parties on the basis of statement of claim and defense. I say, yes, you do that. Have you done it? And there it says that the claimant shall state the facts supporting his claim, setting out section 23, and then saying, but in SOD, the respondent has neither referred to nor disclosed these materials. What materials? My lord, this report of the Director General of Hydrocarbons, the care report, crisis report, etc. My lord, I submit to your lordship, my lord, look at my paragraph. Kindly, this paragraph referred to, kindly see what they have said and what I have said. Well, I'm sorry, my lord, I have to take your lordship to that, because now I am dealing with these decisions. I am saying that this is not an assessment by the arbitrator of, my lord, the evidence which has gone into that. The assessment of evidence is within the jurisdiction of the arbitrator. But then again, my lord, if the arbitrator does not consider the evidence, then this is not an assessment of the evidence. This is refusal to perform a duty which has been cast upon the arbitral tribunal by the court and under the act. There will be infraction of the duty on the part of the arbitrator. I am using slightly stronger language, but my lord, this is what it is. You'll have to look at it from that point of view. Kindly, my lord, come to, my lord, these paragraphs which have been referred to here. Paragraph 48, 52, 53. What is paragraph 48? This, your lordship will please to find statement of claim, page 32. Paragraph 46, my lord, is a claim for specific performance. It is volume 1. This is volume 1. Paragraph 46. So, তোমাদের যে paragraph refer 46, 47, 48, 52, and 53.
Just feeble protest, again, very feeble and humble, protest. Again, going into facts and all again.
I am not going into the facts. I got to citing you before your lordship the decisions and saying this does not apply. Why I am saying so? I have got to, my lord, prepare the ground for it, and I am going to deal with my learned friend's judgments, decisions.
That's why I said very feeble and humble protest. I have already been in Bengali, what they say, my lord, bokuni ke gechi.
Well, the problem is this. Well, I've reached at a stage when I deal with the council, who are my son's contemporary. They were in the same class, same year.
Don't I know that?
No one would know that better than. Just
So,
one of us was their local guardian.
Yes, yes, I know. I know. So, this is the disadvantageous position I am in. Only the other day, before I'm just digressing for a moment. I think, my lord, we have talked enough.
Yeah, enough for today.
Yes.
Disadvantageous position your learned is also in. That is why feeble protest.
Well, that's why I don't try to take advantage. Only the other day, what happened before Mr. Subhasha Bhattacharya, after 3 days of hearing, on the other side, Mr. Somabha Ghosh, led by Mr. Ranjan Bachar, are trying to, my lord, push in and supplementary affidavit. My learned junior was indomitable Mr. Tilak Babu. So, my lord, I told him that you better be there. I am going to be in the background. No, you will have to strongly oppose it. I said that it will not be possible for me to strongly oppose. And when, my lord, the matter was called on, Mr. J. Bhattacharya said, Mr. Mitra, you are appearing for, well, I am being led by Mr. Tilak Bose. Lord, he is going to make this. Then he started laughing.
Stop the live streaming.
না না
না না রাখুন থাকুন না।
500 বার দিন।
Correct, correct. Then you're there, both of you, on Tuesday. Are you there? Tuesday?
Tomorrow?
No.
No. Yes, sir.
Tuesday week?
4th.
4th?
Or my lord, let it be on Monday.
Monday.
Let it be on Monday, my lord. I shall try.
In case there's any difficulty, my lord,
Just if you could give us an indication, roughly how long you will take.
If I, my lord, on Monday, if I start in the morning, I will be able to finish before lunch.
No, but Monday you may not be able to come in the morning.
No, I don't say that I will not be able to come. On my way to the court, I shall stop there.
my learned friend may be a little late. That's what my
Maybe
maybe.
it's a little. That's why I'm saying, my lord, if there are other matters on the list,
No, if you indicate a time period, we can fix the matter.
11:30.
Then you will finish by lunchtime.
I hope so. I hope so. I shall be as quick as.
What if we fix it at 3 o'clock?
3 o'clock.
There is always 3:30 on certain.
No, শোনো।
কি 3:30 কিছু আছে?
কিচ্ছু বলা যায় না। মানে kindly make it at 2 o'clock.
2 o'clock.
এতগুলো জাজমেন্ট সাইড করেছে, কি করবো?
জাজমেন্ট এগুলো সব আগে দেখানো ছিল।
Other matters are there. That is why we are saying, if you permit us to fix it at 3 o'clock.
Well, if there is no other matter fixed, I was submitting if it can be done at 12 o'clock. So I come, make my submissions, finish off before I.
তাহলে Monday,
Monday,
marked 12 noon. Marked 12 noon.
Lordship, very grateful to you. এক গাদা এই সমস্ত